मैडम लैपटॉप
किसका नाम था? हेलो रिकॉर्डिंग आता होते हैं
Dr. Sunita, good morning.
Sabha sir, good morning.
Good morning to you. After a long time.
How are you? After a long time.
Good. So thank you for all
How are
the
you?
association that we are taking.
So nice. That is your seminar?
Our seminar, which one now? Because we are having one on the 23rd with you all. 23rd.
23rd.
Yes.
Okay.
23rd, yes.
And how many
Can't hear you
resource
too
persons?
well. Resource persons, just 2 resource persons. 2.
Okay,
Just 2.
okay. Okay. Acha, are you coming up with any proceedings?
No. We are having NAC inspection on 16th and 17th February. So after that, we will start working on any other progressive things. NAC peer team is visiting us on 16th
You are
February.
having NAC?
NAC. We are
February.
getting
Okay.
peer team.
Second
cycle.
cycle?
Yes.
Second cycle?
Yes, second cycle.
Okay.
Second.
Okay.
We are starting this program at 11 o'clock, no? 11.
Sharp 11 o'clock we'll be starting.
Very good.
Exactly at 11 o'clock.
Very good.
Yeah.
Very good. So you carry on with your work. I'll also do some things and we'll get back. Okay? Your mic is muted.
You're using device audio.
You are using
Speaking it.
I request the participants to kindly introduce yourselves. Yeah, thank you. Hello, good morning. Good morning, everyone, and I welcome you all for this one-day webinar on evolving laws of real estate, which is organized by Progressive Education Society's Modern Law College, and which is in collaboration with VVM's GR Kare College of Law, Goa. And it gives me an immense pleasure to welcome you all for this unique national webinar on evolving laws of real estate. Basically, we are focusing upon two major acts which are in regulating the real estate laws. One is the Real Estate Regulation and Development Act, that is RERA Act 2016, and the other one is MOFA, which is an older act, Maharashtra Ownership Flats Act 1963. So basically, when we are talking about these two acts, we are focused upon the end user, we are focused upon the owners. And while we are regulating all this, we were talking about the benefit which is going to be gained by the end consumer. Okay, so I'll just brief you with the objectives, and I know, and we are looking forward for the experts to throw some light upon this act and how exactly it is regulated. But basically, for our introduction, let me give you a few highlighted points wherein we can focus upon. For example, in the RERA Act, we are talking about usually it was it was charged on the super build-up area. Now it is charged on carpet area. Important definitions are given under the real estate area. Registration of projects and real estate agents is being given in RERA. A tribunal is established and punitive punishments are also established. Powers of making rules and regulations is given to the RERA. So these are all the objectives of RERA and MOFA. When we are talking about, we need to lessen the difficulties, lessen the malpractices related to the promotion of construction. Now more buildings needs to be constructed at a very cheaper rates, and sale of flats and the management of flats. These are the objectives of the act. So this is what we've been focusing upon. Now, after I have introduced the seminar, it is time that we will welcome you all. Right, I have already welcomed you all, but this was an unofficial thing. But officially, we would like to welcome you all by our heads of the departments, heads of our colleges. Right, both the principals will be welcoming you all. It will be a warm welcome. I will be assuring you of that. First, I would rather request our dear principal, Dr. Sunita Adham ma'am, principal of PES Modern Law College, to kindly deliver the welcome address, and then I request. After that, I would request to Dr. Sabha De Silva, Principal VVM's GR Kare College of Law, Goa, to kindly deliver the welcome address. Now I hand over to Principal ma'am. Ma'am, over to you.
A very good morning to all of you. I, on behalf of Progressive Education Society, welcome all of you for this national webinar on evolving laws of real estate. I would just like to tell you briefly about the Progressive Education Society and also about the Modern Law College. Our society, that is Progressive Education Society, is a reputed and distinguished educational institution in Maharashtra. Late Shri Shankar Rao Kanetkar, along with his selfless a dedicated team of the teachers known for their highest moral values have laid the foundation of this society, and it was on the auspicious day of Akshaya Tritiya, which was on 16th of May 1934 in Pune. Progressive Education Society has been making a noteworthy progress for last 87 years along with the noble path and principles which were being laid down by the eminent founder members. The two remarkable words that appears in the name of the society and its educational institute are progressive and modern. The inclusion of these two words was certainly with some noble intention, which serves as a values for Progressive Education Society to follow with determination. The two words, that is the progressive and modern, highlights the aim and objects of this reputed educational institute. Progressive and modern were the terms which were set way back in 1934 to set the dreams and the future roadmap of Progressive Education Society. Progressive is nothing but keeping with the spirit of time and innovation, while modern means modern in outlook, up to date in all matters, whether it is in academics or it is a sports activity or even in cultural activity. Presently, Progressive Education Society is providing education right from KG to PG and even to research, and all is under the able guidance of our eminent chairman, Sir, Professor Dr. Gajanan Ekbote, Sir. Dr. Gajanan Ekbote, Sir, is a surgeon by profession. Dr. Ekbote, Sir, has made his way into the world of administration way back in 1985. Fueled by the desire for the educational excellence, he has accepted the challenging responsibility of leading Progressive Education Society, Pune, as its chairman. It is on account of his proactive approach and also vision that he has been successfully leading 62 institutes which are coming under the umbrella of Progressive Education Society. Progressive Education Society's Modern Law College is one of the premier legal institute providing education in law, which is situated close to Savitribai Phule Pune University. Modern Law College was established in the year 2003. Though the college is very infant, but still it has carved a niche for itself. College is permanently affiliated to the university, that is Savitribai Phule Pune University. It is also recognized by Bar Council of India. It is also recognized under Section 2F12B of UGC Act, and it is also accredited by NAC Bangalore. The college stands as one of the best law college in Pune. All the courses of the college are approved by university, which includes 3-year program, 5-year program, that is BLLB, Masters in Law, various diploma courses, and even certificate courses. The academic excellence of the college is manifested from the results of the students of Progressive Education Society's Modern Law College, and it is not only in academics but also sports, curricular, and extracurricular activities. Students have really won laurels for the college in various national level, state level competitions. We also accommodate various foreign students, maybe from countries like Iran, Sri Lanka, Afghanistan, Thailand, and also South Africa. And we pay special attention to their orientation, counseling, and also problems faced by them. Every year, college organizes various national, international, and also state level seminars. But this year, it was because of the COVID-19 pandemic situation, we were unable to organize the seminars. But of course, we are very much on organizing the webinars. This is our 4th webinar, and it is the 2nd national webinar in this academic year. This national webinar is on evolving laws of real estate. Recently, in 2016, a special law was enacted to regulate real estate. That is the Real Estate Regulation and Development Act, which aims to establish the regulatory authorities that would regulate and also promote the real estate sector. The aim of the act is to protect the interest of the home buyers and also promote timely delivery of the properties or even the projects. RERA is also enacted to boost the investments in the housing sector. Today, we have with us eminent speakers in this field who will be sharing their knowledge with us on this topic. We have with us today Dr. Chandrasekhar Prabhu, who is the ex-president of MAHADA. We also have Dr. Santosh Kakade. He is a member, State Consumer Redressal Commission, Maharashtra. We also have Honorable Shri Pradeep Joshi sir, who is a member, State Consumer Redressal Commission, Maharashtra. And his special thing is he has a vast experience of deciding consumer matters related to real estate. And we also have Dr. Uday Varunjikar, who is a renowned lawyer practicing in High Court, Mumbai High Court. I welcome all of you for this webinar on evolving laws of real estate. Thank you.
Thank you, ma'am. Now I request our collaborating college principal, Dr. Sava B.M. Da Silva, sir, principal of BBM's GR Kare College of Law, Goa, to kindly give us the welcome address. Over to you, sir.
Thank you, Assistant Professor Pavan Kalwala, and especially my colleague, Dr. Sunita Adav, who is the principal of Progressive Education Society's Modern College of Law. And it is my pleasure to be associating with your college, ma'am, for the numerous programs that we have had so far. You are one of our valued MOU partner in this regard. I would, at the outset, briefly tell the audience of the background of our institution. The Govind Ramnath Kare College of Law is one of the institutions under the Vidya Vikas Mandal banner, which is an education society, which is currently in the 50th year of existence. So it is a very timely year for us. It is the Golden Jubilee celebrations of Vidya Vikas Mandal. And apart from Govind Ramnath Kare College of Law, it also, the Vidya Vikas Mandal also has another higher education institution, and that is Sri Damodar College of Commerce and Economics, which offers BCom, MCom, BCA, BBA, and also the PhD degree in management. So these are two higher education institutions, and we have two higher secondary schools. One is called the Ramakrishna Mahadev Salgaonkar School, which offers commerce and vocational studies. And we also have another English medium school, which is under the CBSE board, which offers science education up till the higher secondary level. All of these are in a very conducive campus of the main city of Margao, which is the capital of the South Goa district. So that is just to tell you about the base of what we are. But coming specifically to Kare College of Law, it is about 42, 43 years into existence now. It is for about 40 to 42 years in existence now, and has produced a lot of stalwarts in law. We have contributed to the judiciary. We have persons who have been in practice both in India and abroad, and we have contributed to the legal academics in numerous ways. Initially, we started with the 3-year program in law, but for about 20 years now, we have the 5-year program. We call it the BA LLB program now. And prior to that, we had the LLB honors program. We also have the master's program in law, the LLM, and Kare College of Law is also recognized as a research center for doctoral studies. I am currently the dean also of the Faculty of Law of Goa University, and we are taking a lot of giant strides in the progress of our institution. It is an institution which is recognized by the Bar Council of India, also by the UGC under Section 2F12B, and we do have a recognition of the NAC for which we are about to enter into our second cycle of accreditation. We are being visited by the peer team next month. Now, Kari College is known to have a whole lot of memoranda of understanding with institutions, including overseas. And in this year itself, it was a year of a lot of webinars. We've had 3 or 4 international webinars and numerous national and state webinars, kept us busy round the clock. And it was possible to a great extent because teaching has all become remote over the year. There are 2 colleges affiliated to Goa University, and we are the college in the south. We have felt the pulse of the system and associated with a whole lot of organizations to conduct programs. We have rank holders of the Goa University every year. Our results are excellent. And I'm happy to say that last result of the Goa University was topped by Kari College of Law, wherein our student secured a record percentage of 78% or around 78%, which is very remarkable. Now, coming to the seminar itself, or today's webinar itself on evolving laws of the real estate, I actually congratulate the Modern Law College for taking up a topic which is so vital and dear and so timely for them. And I also thank Modern Law College for associating with our college and making it a team effort so that we can give the audience a very compact picture of what lies ahead in the real estate. And I welcome each and every person on this platform present right now, in particular, the resource persons of the technical sessions. No doubt Dr. Sunita has already mentioned their names, but I will mention them again. That is Dr. Chandrasekhar Prabhu. Then we have the second session by Dr. Santosh Kakade. And we have Mr. Pradeep Joshi, who is from the State Consumer Commission. And of course, we have Advocate Dr. Uday Varunjikar, who is going to take the fourth or the last session. Now, at this juncture, I wish everyone present here a very happy learning experience. And I once again thank Modern Law College, in particular Dr. Sunita Adhav, and I welcome everyone present to this webinar as warmly as it could be. Unfortunately, for this pandemic, otherwise we would be all physically meeting for a program like this. Thank you, Assistant Professor Pavan Kalwala, for your anchoring of the program as well. Welcome.
Thank you. Thank you so very much, sir. Now it's time we've been waiting for. The first technical session we'll be starting with, and to introduce our resource person, Mr. Chandrasekhar Prabhu, who is an ex-president of MHADA. I would rather request Assistant Professor S.N. Inavali, sir, to kindly introduce the resource person, who is also an HOD of GR Kare College of Law, Goa. Over to you, sir. Thank you.
Thank you, sir. Respected principals of both institutions, respected resource persons, esteemed colleagues from both institutions, and participants. It's my immense pleasure to introduce eminent personality, Shri Chandrasekhar Prabhu is an architect, professor, editor, painter, artist, TV anchor, educationist, administrator, housing, urban development, management expert who has held public and corporate positions of repute. Shri Prabhu graduated from Sir J.J. College of Architecture, Bombay University. In his pursuit of knowledge and excellence, took him to universities in UK and the United States of America. He has since been invited for lectures on housing and urban management issued by universities, uh, issues housing and management, urban management issues by universities all over the world. He has been teaching architectural design, urban design, humanities, etc. for over 20 years. He is a fellow of the Indian Institute of Architects and Indian Institute of Interior Designs. Prabhu was the youngest member elected to the State Legislature Assembly. He never looked back since then. As a chairman of Santa Cruz Electronic Export Processing Zone Committee, he became one of the very few professionals having hands-on experience in conceiving and implementing the SEZ dream. While serving on the authority of Mumbai Metropolitan Regional Development Authority, he played a crucial role in framing policies on urban development and implementing them successfully. He was elevated to the post of President of the Maharashtra Housing and Area Development Authority, which is a cabinet rank position. His multidisciplinary interest led him to accept the post of Chairman of Drugs and Pharmaceuticals Committee of Government of Maharashtra. He was advising successive chief ministers and was appointed the Chairman Advisory Committee, Department of Housing, Government of Maharashtra. One of his responsibilities was to outline the state housing policy and interact with the union government regarding issues pertaining to the national housing policy. Shri Prabhu has submitted to the state government a detailed vision document which is exhaustive in 12 volumes. Shri Prabhu has also served as a member of the Slum Rehabilitation Authority and created alternate model of self-redevelopment. He was one of the founders of Intel and served as its convener, heading the Maharashtra state chapter for over a decade. His interest in heritage led him to head the Heritage Committee of the Indian Institute of Architects and was finally in charge of the project to document the best heritage practices in SAARC countries. Prabhu conducted a weekly live show on Doordarshan, which completed 400 episodes. He also worked on the independent monitoring panel of the World Bank project, such as Mumbai Urban Transport Project and other projects. He made his corporate debut by working as a CEO of Shogun Multiplex Limited, a company conceived to facilitate collaboration with international funding organizations for executing mega projects in the spheres of entertainment, infrastructure, building multiplexes, and creating environment. Prabhu has had a long experience in the field of education. He was the chairman of the advisory committee of the Pravara group and was responsible for framing of the first proposal to a private university covering 1 lakh students. Prabhu served as the trustee of one of the oldest education trust set by Parsi community called Barda Marzban Education Trust. Prabhu conceived and presented the concept and vision of the world's first green city, which was to come up on 1700 square kilometers at Haldia in the state of West Bengal. In his editorial experience, having edited Journal of the Indian Institute of Architects, leading magazines on infrastructure, construction, apart from writing columns in 16 national publications in 4 languages. Prabhu has also advised corporate bodies such as Mahindra Lifespace, Urban Infrastructure Venture Fund, Collective Research Initiatives Trust, etc. Prabhu was Director General of the Maharashtra Economic Development Council, its chief advisor, chaired the editorial board and edited magazine Economic Digest. Shri Prabhu is presently is a advisor to several corporate groups, including banks. He is not only considered to be the founder of the People's Movement for self-redevelopment of corporate housing societies, MHADA colonies, old and dilapidated cessed buildings, slums, but actively involved in the activities of several NGOs working with residents, tenants, slum dwellers, mill workers, etc. His painting has been awarded numerous awards and are rated highly by senior connoisseurs and art critics. And once again, I feel that it is a pleasure to introduce such a versatile person. And I wish that Sir Chandrasekhar Prabhu will enlighten us on RERA Act advantages and disadvantages. Welcome you, sir, and over to Sri Chandrasekhar Prabhu. Thank you.
Thank you for the kind words said about me and the introduction. And welcome to you all. Thank you for the organizers for taking up this subject and having me over today to talk to all of you. I'm known for my frankness, and I shall not mince any words in making things very clear to people. I shall call a spade a spade. And a disclaimer, which I always mention before I make any of my speeches, that in the duration of my speech, I shall be saying the truth and only the truth, which is at times likely to hurt a few feelings. And so I apologize in advance for any feelings that I would hurt at any stage in my speech, so that I don't have to do that again. So let me start with the subject very clearly from the beginning. What is RERA? Real Estate Regulatory Authority. What is real estate? Real estate involves construction. Who are the players in real estate? The owner of the land, the person who designs the building, the person who funds the building, the person who gets the contract to build the building, the person who makes profit out of the building, the person who sells the flats, the person who buys the flat. These are by and large the preliminary and principal players. And who are the subsidiary players? There are many subsidiary players. I shall not go into the details of it. So we have understood real estate. What is regulator? Authority, everyone knows, is for regulation. And what is a regulator? Have we seen any regulators in the past? And what has been the functions of the regulator? We have seen Electricity Regulatory Authority. We have seen Post and Telegraph Regulatory Authority. We have seen Telecom Regulatory Authority. We have seen several regulatory authorities. What is the primary role of a regulatory authority? What does a regulator do? Regulator regulates. What does he regulate? With the Telecom Regulatory Authority, the regulator decides the tariffs. With the Electricity Regulatory Authority, the regulator decides the rate at which the electricity can be given to the consumer. With the Ports Regulatory Authority, the regulator decides what is the rate at which the ships can be docked in the port. At the Airport Regulatory Authority, the regulator decides at what rates the planes can be parked. Now, Real Estate Regulatory Authority, what was it expected to do? It was expected to make real estate within the reach of a common man. For that, what it needs to be done is to regulate the prices of real estate. Does the Real Estate Authority have a right to regulate prices of the real estate? Answer is no. So what is the regulator going to regulate? Regulator is only going to regulate the contract, the agreement between the builder and the buyer, and ensure that the builder fulfills the points mentioned in the contract vis-a-vis the buyer. It is very common knowledge that when you go to buy a flat, the builder produces an agreement before the buyer, and the buyer wants to get a good price. The regulator is not supposed to interfere in what price the buyer is going to get and what price the builder is going to sell, because that is not part of the regulatory authority's mandate itself. Therein lies the major flaw in the regulatory authority. The only primary job of a regulator is to regulate the rates and prices, which is kept out of the purview of the regulator. So what does he do? The builder, when a buyer goes, the builder produces certain documents which the buyer is supposed to sign. Does the buyer get a chance to revise those documents? Answer is no. What the builder writes in this document, does the buyer in most cases understand? Answer is no. Most probably he goes there in front of the registrar and that's where he just signs the document. Because the document is wholly and completely one-sided in favor of the developer, because the developer produces it before the buyer and the buyer signs. And then the RERA is supposed to be an authority which is supposed to implement the clauses signed by the developer and the buyer. If the developer doesn't implement those clauses, why would the developer not implement those clauses? Because most of the clauses are in favor of the developer. The buyer has no say in what agreement is made. So if a developer admits to certain points vis-a-vis the buyer and then defaults on the point, only then the RERA comes into the picture. So the RERA's role is very limited. If you define the role of a regulator overall as to what a regulator should do to make housing affordable to the people, out of 100 points, the RERA is authorized to act only maybe on 10 or 15 points. So 85% of the requirements of a regulator that should have been there are not there within the purview of RERA. I agreed to be a part of this seminar because it talks about the evolving law. We want this law to be evolved, to evolve further and give more powers to RERA to incorporate such things within RERA which are presently not there. All the chiefs of RERA, including the chairman of the Maharashtra RERA authority, has written to the government that the powers given to RERA or the scope of RERA needs to be expanded. And continuous reminders to these letters have been given to government. So far, nothing has been done, but unless there is pressure on the people, on the government from the people, these changes are not likely to happen. Why is there no pressure? A simple thing. Take a city like Mumbai. The other cities are lesser than Mumbai. So let's take an extreme case of a city like Mumbai. What is it that Mumbai does with a V to real estate? How many flats are sold every year in Mumbai? Any guess? Forget the pandemic this year because hardly 6,000 or 7,000 flats have been sold. But in the best of years, 20,000 flats get sold. So if 20,000 flats get sold, what is the population of Mumbai? The population of Mumbai is 1 crore 25 lakhs, out of which how many people are affected by RERA? 20,000 people who buy flats. which means less than 0.01% of the population. And what is RERA supposed to achieve? It's supposed to achieve affordable housing. It's supposed to achieve housing for all. If it doesn't affect more than 20,000 people in the city of Mumbai out of 1 crore 25 lakhs, how is it supposed to achieve all the objectives that it is supposed to achieve? No, it cannot. It is only when a developer says, I shall give you a flat within 2 years, and then he defaults. If he says, I shall give you X quality, and he doesn't give that quality. Incidentally, in none of the agreements with the builder does the builder promise the quality. And finally, what happens in this entire thing is that the buyer who buys from the builder, only he can go to the authority. Again, coming back to the example of Mumbai, Mumbai doesn't have vacant lands anymore. Whatever the lands in Mumbai are there have been occupied. They are either occupied by cooperative housing societies held by private individuals. The cooperative housing societies, we have 45,800 cooperative housing societies. We have 1 million people living on MADA lands. We have 7 million people living on slums, which occupy 12.5% of Mumbai's land. We have 1 million people living in quarters given to the employees by the respective employers. We have another 1 million people living in MADA colonies. And we have 2.5 million people living in old and dilapidated cessed buildings. So, who is the builder going to address? First, he needs land. And if he needs land, he has to take land from these various people who are presently occupied land, because vacant land is not available in a city of Mumbai. And there are people living. All the residents of Mumbai, that is 1 crore 25 lakh people, are living on the land which the builder takes, redevelops, and sells the flat. But in those schemes, the flats which are sold by the builder, the buyers have a right to protection from RERA, but the original residents of the land on which the people are living have no protection of any nature whatsoever from RERA. So, the law, I was the one who insisted from day one that we need a regulator for the real estate. And the regulator came, we welcomed it. But the scope that was given to the regulator was so restricted that the regulator doesn't make any difference to either the city of Mumbai or to the residents of Mumbai. If at all it makes any difference, it makes difference to the 10 or 20,000 people who buy flats from the developers. So in a city of 1 crore 25 lakhs, if 20,000 people are affected by RERA, you cannot say that RERA is beneficial to all concerned. We have to make it beneficial to all concerned, and for that, what is required is to enhance or widen the scope of RERA, to incorporate all those within the purview of RERA whose lands are being occupied for redevelopment. We also need to ensure that the prices are kept in certain amount of control. I'm not for reducing the prices or telling the builder, no, you can't sell at this price, you can't sell at that price. But assuming a builder informs the RERA by giving his balance sheet that I am going to sell a particular flat at 20,000 rupees per flat. Who is telling this? Not me, not the authority, not the activist, not the expert. The builder is telling. Now, if builder has informed the government that he is selling a particular flat at a particular price, If a consumer sees this averment by the builder and goes to the builder and say, okay, you have informed the government that you are selling the flat at 20,000 rupees per square feet. I want to buy it at 20,100 rupees per square feet or 20,000 rupees per square feet, the price at which you want to buy. Is he entitled to buy? Can the RERA tell the builder, you are selling it at 20,000? Mr. Prabhu wants to buy it at 20,000, give it to him? No, the RERA doesn't have the right. The only right RERA has is to go through the agreement, which is completely one-sided. There have been innumerable Supreme Court judgments which has said that the agreements between the buyer and the seller being the builder and buyer being the new person who doesn't have a home who wants to buy, cannot be one-sided. It has to be balanced either way. When the Supreme Court, time and again, the latest judgment came only 2 days ago, when the Supreme Court said that the agreement between the builder and buyer is one-sided and hence it doesn't follow the principles of equity which are required under the Constitution of India. And on this ground alone, it being one-sided, we set the agreement aside and the buyer should be given what were his. It's a separate case. It's a case in Gurgaon. I shall not go into it. But what I'm trying to emphasize is time and again, Supreme Court in successive judgments has been telling the government, both at the center and at the state and in various judgments, that agreements between the builder and the buyer cannot be one-sided. But there is no model agreement that government makes and tells the builder that, look, these are the rights of the buyer which you need to incorporate in your agreement. If you don't incorporate, then that agreement will not be considered because it will then be one-sided, and Supreme Court has ruled that one-sided agreements are not permissible. That has not been done. So what does the RERA do? That it just becomes a timekeeper. If in the agreement the buyer has paid the money and the developer has said that if you pay the money, then I will give you flat on X day. And if he has not given, then RERA says, okay, if he has not given, either give the money back to him or give him interest. Builders in Mumbai are extremely happy with this situation. Please understand. Under the RERA, if the builder doesn't give the flat on time and RERA says you give the money back, builders are happy. Because if they give the money back, they have to give at 9% interest the money that they have taken. All builders in Mumbai borrow from the market at 2% interest per month. That is 24% per annum. So when you are borrowing at 24% per annum for your project, here, if you take money from the buyer and don't give him a flat, then you tell him you take your money back with interest at 9%. Even then, he stands to gain 13% because instead of buying from the market, he gets unsuspecting buyers and promising them the world and then doesn't agrees to give them the money. So this law needs to evolve. This law needs to cater. Whom should it cater? The person who doesn't have a house. Whom should it cater? The person who doesn't have adequate shelter. The government's avowed policy is housing for all. The government's avowed policy is affordable housing. What is affordable housing? Let us not go by international definitions of affordable housing. Let us not go by United Nations definition of affordable housing. Let us not go by World Bank's definition of affordable housing. Let us go by the definition of the Indian government on affordable housing. The Government of India, Planning Commission, Niti Aayog, all agencies of the government of India, the Housing and Urban Development Department has time and again said that what is affordable? 5 years annual income of a person or a family. Within that amount, if you get a house, then the house becomes affordable, because then the installments for that particular flat that is bought become affordable, because if within 5 years annual income it is there, then the EMIs are such that after paying the EMI, you can take care of your family. Let us take Mumbai as an example. I'm sorry, because I come from Mumbai, I would like to take Mumbai as an example because it's an acute situation where there is housing shortage and tremendous amount of demand. Other cities may vary. I have done detailed studies of all the cities in Maharashtra, and I have my students who are doing their PhD and master's degree under my guidance have been kind enough to do detailed studies about all the cities. But let me now talk about Mumbai alone. The cheapest, the cheapest possible house anywhere in Mumbai is not below the price of 12,000 rupees to 13,000 rupees per square feet. Now, 12,000 rupees per square feet, you get it in Dahisar or Bhandup or, godforsaken places where many people don't go, far away from the railway station, no communication means, a little difficult to, even there it is 12 to 13,000 rupees per square feet. Near a railway station, anywhere in Mumbai, the prices are 20,000 rupees per square feet. So a decent house, even in the farthest corners of Mumbai, at 12,000 rupees per square feet, a decent house of 600 square feet at 12,000 rupees per square feet would still be 75 lakhs of rupees. Now divide that amongst 5. So that means in 5 years, your earning should be 75 lakhs of rupees, which means 15, if it is 15 lakhs of rupees per year, which means 1,10,000 or 1,20,000 rupees per month. If you earn, only then you can afford a house in Mumbai at the remotest corner. Forget the better areas where the prices increase. So in the remotest corner of Mumbai, if you need to afford a house, the house comes in at a price of 75 lakhs of rupees, and your earning to service such a house has to be 1,10,000 or 1,20,000. Now, how many people in Mumbai earn 1,20,000? The income tax payers, the income tax department has made its statistics very clear that those who earn more than 12 or 15 lakhs of rupees per annum in Mumbai are not even 2% of Mumbai's population. If 2% of Mumbai's population can afford a house, then can we make housing for all? Can we make housing affordable? The government knows very clearly what is the price at which the land has been bought. The government knows very clearly what is the rate of construction. The government knows very clearly at what rate the money has been borrowed by the developer. So, the cost of the land, the cost of borrowing, the price of construction, the price of paying all the professionals, the price of paying all the duties and taxes and premiums and all that, and load on that a profit 25%, 30%, 35%. I'm not against a builder making profit. But could there be some upper limit wherein you cannot go beyond? I know of lands in Mumbai which were government lands in Powai and other places, which were given to developers several years ago at 5 rupees, 6 rupees a square feet. The cost of construction, as a senior architect who has been teaching architecture all my life, is not beyond 3,000 rupees per square feet. I'm talking of the upper limit. All the premiums put together will not go beyond maybe 2,000 or 3,000 rupees per square feet if you take the average, including TDRs and all that, because TDR, there is a free FSI and there is a FSI for which you pay the TDR. So it evens out. Now, tell me if the land, the cost of borrowing, the cost of construction, the cost of premium, the cost of TDR, everything put together comes to around, say, 8,000 rupees a square feet. And if a developer is charging 35,000 rupees a square feet, you think that is going to create affordable housing in this city? So the regulator is not supposed to ask the developer what the price is and why the price is at that price. So the law needs to evolve. All over the world, the definitions are left to the experts, the architects, the engineers. The definition of carpet area and built up area are known to the professionals. What is a carpet area? You go inside a room and measure the length of breadth. That is the carpet area of that room. You measure all the rooms in a flat, including the toilets from inside and the passages, and add all the carpet areas of the room. That becomes the carpet area of the flat. This was the conventional definition all along. I have been teaching architecture for 35 years, and all along this has been the definition which we have been teaching. All over the world, this has been the definition. However, the Maharashtra RERA finds a new definition. How can the authorities and the government change the definition of carpet area? It says within a flat, there are walls. So the area under the wall should also be counted in the carpet area. That is never there in the definition. The definition of the carpet area says you go in a room from wall to wall, measure the length and breadth. Length multiplied by breadth is the area of that room. Now, wall to wall, where the carpet can go, carpet cannot go under a wall. But RERA says no. Where the wall is, consider wall also as a part of the carpet area. Why did this say that? Because the new RERA carpet area is at least 6 to 8% more than the conventional carpet area. So on one hand, you insist that the builder should be paid as per the carpet area. On the other hand, you insist that the builder in his agreement should mention the carpet area. And then you change the definition of the carpet area to bring it to halfway down between carpet and built up, and say this is a new carpet area called RERA carpet area. When I go in universities abroad and narrate these instances, they laugh. They say like length and breadth can't change, like foot and meter can't change because it's a universal way of measurement. Similarly, universal way of measurement of carpet and built up area is simple. Carpet area is where a carpet can be laid within the flat, whether toilet, whether passages, whether bedroom, whether living room, wherever. Wherever a carpet can go is a carpet area. Wherever carpet can't go, you include, that becomes a built up area. Now, that difference between carpet and built up, which a layman also understands, unfortunately, the powers that we don't understand or are pressurized into not understanding. So my contention is that at least the definitions, leave it to experts. Don't leave it to the builders. Don't leave it to those who benefit out of it. If you really want to make affordable housing, if you really want to make laws to make universal housing affordable for all. Housing for all is what the Prime Minister says. Housing for all is what the Housing Department says. Housing for all is what the Niti Aayog says. Then leave the definition, at least don't alter the definition to benefit someone. I told the Chief Secretary of the government of Maharashtra in a public meeting in front of everybody. I said, sir, you are the highest paid bureaucrat in the state and perhaps the country. Knowing by your pay scales, one can easily deduct that you must be getting somewhere around 2 lakhs of rupees per month as your salary, including perks and allowances. Now, at 2 lakhs of rupees per month, your annual salary would be 24 lakhs of rupees. Your 5-year salary will be 1 crore 25 lakhs of rupees. If a chief secretary's 5-year salary is 1 lakh 25, 1 crore 25 lakh rupees, I asked the chief secretary with humility, let me ask you humbly, the area in which you live, can you get a garage in 1 crore 25 lakhs of rupees within the price? So if a highest paid bureaucrat in the state of Maharashtra cannot afford a house in the area where he likes to live after his retirement, then can the housing be affordable to the common man? If a person employed in a software company, a software engineer who earns a lakh of rupees, lakh and 25, if he doesn't get a flat in that city for 75 lakhs or 1 crore of rupees, then can he afford a house? So, affordability of housing, making housing affordable, if that is one of the aims and object of the law, which it is, to make real estate smooth, RERA is not there to fill the pockets of the builders. Builders are one of the players and their interests have to be safeguarded. There is no doubt about that. They are every player in this game, his interest has to be safeguarded, but you can't discriminate one against the other. So you need to take a holistic look of the entire situation. And unless you really understand the problem, unless you understand the problem in its entirety, you do not find a solution. And unless you find a solution, the demand is going to outstrip the supply, the market is going to be skewed, and the common man, the middle class, the young person, the new graduate, the doctor, the engineer who have taken education and they are upcoming and emerging, who need a house. In a city like Mumbai, there is no way in which where they can even dream a house. Forget Mumbai, even in places like Pune, the kind of commuting that you have to do, because houses are available, but they are available far away. You need to go beyond the highway, sometimes, way beyond. I have seen people live so far away from their residences and they have to commute up and down, taking 1 hour, 1.5 hour to commute between the place. And then there is traffic jams, there are accidents, and there are major things. So what is really affordable housing? What is really adequate shelter? Adequate shelter is adequate space, good quality of space, good environment, good means of construction, and good access to place of work and worship. Transportation, environment, space, and a chance to increase the quality of space, including incremental housing. See, when a husband and wife decides to buy a house, they are just married, so 1 bedroom, all kitchen does for them. Then they have children within a couple of years. The children grow up. By the time it's 10 or 15 years, you require an additional bedroom for the children. If you have two children, perhaps you require two bedrooms. But our system doesn't provide for incremental housing. So once you buy a house, you require an additional bedroom for your son or your daughter within your house. But when they grow up, they have to go and buy a separate house. Instead of doing that, if we plan or design our buildings in such a way that the regulatory authority says, okay, today this is your plan. But what happens 25 years down the line? Is there any scope for increment? Can these people's needs with regard to space, with regard to amenities, with regard to environment be fulfilled? If the answer is yes, then it is a good plan. It needs to be approved. So the scope of the regulator needs to improve. The regulator should be the sole law-giving authority to provide adequate shelter within affordable means. And for that, what needs to be done? No one grudges if the builder makes profit. Sure enough, the builder works hard, invests his money, so he should make a profit. No one wants to grudge profit to the builders. But profit making is one thing and cheating and looting is another thing. What is happening today is cheating and looting. As I told you, 5 rupees per square feet land, 8,000 rupees is the investment and 35,000 becomes the selling price. Now, when such things happen, is the regulator going to put his foot down and say, well, you can do it? Or is he going to say, no, you cannot do it? Today, if the electricity is sold at 5 rupees per unit, if tomorrow some private dispenser of electricity comes and says, no, I shall sell it for 25,000 rupees per unit, the regulator immediately comes and says, no, you cannot sell it for 25 because it is not affordable to people. You have to sell it for 5, or if you convince me that it needs to be improved, it could be 5 rupee 25 paise, 5 rupee 30 paise, 5 rupee 50 paise, or whatever the case may be. So the regulator has the powers to decide what price the consumer should get the commodity. Here the commodity is a house and the regulator has no authority. So is RERA a good law? I asked for the RERA. I wanted a regulator. So a regulator has come, I'm happy. But the powers that you have given him, the authority that you have given him aims and objectives, but you have not given him the powers to apply the aims and objectives. So in cases of redevelopment, the RERA should be applicable to slum dwellers, cooperative housing society. So every slum dweller is one of the consumers. It has to be applied to the cooperative housing society. So every member of every cooperative housing society becomes a consumer and he can go to the RERA and ask for his rights. It should be made applicable to MADA colonies and the residents of MADA colony. It should be made applicable to all the tenants cooperative housing societies, or otherwise, even if there is a landlord-tenant relationship and the building goes for redevelopment, then RERA should also take care of the rights of the tenants, and no landlord can just go and say, here, take your money and get lost from here, because the Maharashtra Rent Act provides certain rights to the tenants. So human rights and the rights of the people ought to be part of the RERA authority. So regulation means to ensure that the population of the state is contented. There is a good chance for them to live. There is a good environment. There is good space. There is good education. There is good means of communication. There is good. So all these things have to be provided. Either they have to be provided by the state government, or they have to be provided by the developer, or they have to be provided by any other agency like the MMRDA, municipal corporation. So the responsibility needs to be fixed, and that is what the RERA law should be. So evolving laws, as we are saying, finally after 50 years of independence or 60 years of independence, we have finally a regulator for real estate. Now that regulatory law should evolve and should make it such that every individual who lives, like we say, roti, kapda, and makan. So makan is, I mean, stay is a part of the fundamental right. Right to live encompasses right to housing, and that has been accepted by the Supreme Court. So if our constitution provides us the fundamental right to housing, then it is absolutely essential that there should be an authority to immediately implement that right. And that authority should be the RERA. So, with new laws coming in, old laws being archaic, the MOFA Act was replaced by RERA Act. So, the new law has come and the law is inadequate. It doesn't cater to all, it doesn't take care of the concerns, it still causes problems. So there is a need for drastic reforms, there is a need for evolution of this law. Let this law be all pervasive, let it help everyone, let it extend itself to every individual residing in the state of Maharashtra, in urban areas or maybe in rural areas as well. Anybody who needs housing, anybody who is sitting on land, anybody who provides the infrastructure and wherewithal for the builder to redevelop should be covered within the purview of RERA. And all the issues which are pertaining to making housing affordable to the person who needs it the most should be incorporated and made a part of the RERA. Only then can the government say that we have done something for housing for all. Only then can the government get back and say that we have done something which gives solace. And if you ask 100 people out of in Mumbai that if God were to meet them and tell them, ask one boon, I'm sure at least 99%, if not the all 100 would say, hey, give me a house. So giving a house is important, and making the house available is also important, and making the house available at a price which is affordable to the person is equally important. And the law as it stands, unfortunately, doesn't cater to the entire population. So here is an appeal. I have made this appeal to the earlier government, to the present government, to the central government as well. I was asked to make a presentation to the Niti Aayog, which I did, and they are telling me that they are working on it and they are making changes. I had a chance to speak to a group of judges who wanted to understand these laws from the perspective of an expert in urban development. I spoke to the judges as well, and they completely agree with us, but they are not the lawmakers. So now it is important that we take this message to the people. And when the people understand that this law has to be made more pervasive and the law has to cover everybody, and the people then go back to those who they elect and tell them that unless you do this, you shall not get our support or votes. And when the people at large start emphasizing of what their powers and what their rights are, right to housing, which the Constitution gives us, the Supreme Court acknowledges, it is that if the people start emphasizing, then the cities will change, the state will change, the country will change. All over the world, right to housing has been acknowledged as a basic fundamental right. So has our constitution. The Justice Krishna Iyer very lucidly mentioned several years ago in one of his judgment that right to live is there, and no living is enough unless you have a shelter above your head. So right to live encompasses right to housing. So right to housing is part of the rights given to us by our constitution. And to implement that, you need regulators. You need regulators who have powers to ensure that housing goes to the last person. You know, Gandhiji said, until every tear from every eye is wiped out, my country will not be happy. And you wipe the tear from the eyes of the people only and only when you give them proper accommodation. And RERA is a good opportunity to do that precisely. We have this opportunity, but we are not moving. It's been 3 or 4 years since RERA has come. Now it's a time to review it and say, good, we have a law. So now let us give the law teeth. Let this law not be toothless. Let this law cater to the people for whom it was meant to cater. Let us apply ourselves. So I appeal to all law graduates, all the big lawyers who are there today, all the students of law, all the professors of law, to sit together and brainstorm and make suggestions for changing in RERA, so that RERA will evolve in such a way which will solve the problems of the people, not create more problems. So law is there, we are happy, but it should be better than what it should be. And unless the law provides for accommodation to every single person within his rights. If you ask me, someone may ask me today, I think I have taken my time and I do not have much time available. But if I am told this is not within the purview of law, and here we are addressing lawyers and lawgivers, but if you ask me how every individual in the state of Maharashtra, based on what his earning is and what his capacity to pay is, how he can be given a house within his affordability, I have solutions. I have given one volume with 300 or 400 pages, 12 volumes to the government, giving complete details. I do not know what the government did with those volumes, but I got a gold medal from foreign universities for doing this research. So I'm happy. I always tell the people in government that please don't mind if I point out mistakes in what you are doing, because that's what I'm supposed to do. I go to universities abroad where they ask me what are the laws in your country and are they successful or not. So I have to do that. That is my duty. I'm doing my duty of pointing out mistakes and lacunas in your law, but I'm not happy with it. I want a situation where I want to go to MIT, Massachusetts Institute of Technology, or at Oxford where I go for lectures, and tell them very clearly that my law is good. I'm happy that my country has given law which every person is happy, but that doesn't happen. So the good thinkers, the good lawyers, the person who understand law should suggest to government amendments to these laws which would make housing really housing for all. Government gives slogans, housing for all, affordable housing, but that doesn't happen. Everyone knows that housing is never affordable. So let us make laws to make housing affordable. Let us make the changes and amendments to the law. Only then I think we shall be doing our duty and job well. I think I have taken enough time. I do not want to exceed my time. Thank you very much for having me at this seminar. And as usual, I've been frank. I have put my views in as many words as possible. I would be very happy to reply to any questions that you have, whether we can have it now or later. The organizers should decide. Thank you once again. I think the next thing can.
Thank you very much for your valuable inputs on the subject. As an expert in housing and urban development, you have given a practical approach to the subject, and you have highlighted both advantages and disadvantages of RERA. Definitely, the thought which you have shared with us help us in understanding the subject, understanding the law, and I wish that participants have a good number of questions to ask or doubts to share, and that will be done at the end of all the sessions. Thank you, sir. Thank you very much. Over to Pawan Kalwale. Over to you, sir.
Yes, sir. Thank you so very much. Sir, yes, we'll be taking the questions at the end of the sessions, no doubt about it. But there is a question, sir, if you can address it in few seconds. That
Yes.
will be nice of you. One of our students have asked that if RERA is not yet complete law in benefit of consumer and the builder as well, then are we trying to amend this law? And if yes, what is the progress of that amendment?
Well, we have suggested to government uh, uh, a few things that they need to do to amend the law. Why we? The existing RERA authority, which is chaired by none other than Mr. Gautam Chatterjee, is a fine officer. He has been implementing the law for 3 years and he has been facing hurdles. He said that expand the scope. He has given in writing, of course, being a government correspondence, it may not be available in public domain. I know for sure, we have had discussions with him and I share platforms with Gautam Chatterjee. The RERA itself has given a list of suggestions, I think about 50 suggestions as to what needs to be done to ensure that RERA is used for uh, bettering the housing quality and making housing affordable. For instance, one of the suggestions they say that RERA has no right to go and check the quality of construction. In the agreement, the buyer says the flat is given. The flat I have bought, buyer pays the money, the builder says flat is given. The Municipal Corporation, Bombay Municipal Corporation Act or any Municipal Corporation Act doesn't make it binding on the authority to issue a completion certificate that the quality of the building is as per required, because the engineer is not supposed to check the quality at all. It is not within his duties at all. So put the checking of quality as a part of this thing. So at least someone who's buying will get a quality, and if he doesn't get a quality, he can go to RERA and say, here RERA says in the agreement, he has said you will get 525 square feet. Have you measured? Is it 525? Has he handed it over to you? Has it handed it over to you on time? Okay, if he has done, then there is nothing we can do. Arey Baba, the floor is leaking. One of the most prominent builders has given cardboard partitions in place of wall in a 80-storied building, and it had come in the YouTube. I was just seeing, and the concerned person, they went to RERA. They said, look, as long as there is a wall in the agreement, it has not been written that the wall should be of what material. The plan shows the wall and the wall is there. If it is of cardboard, it is of cardboard. There is nothing in the agreement, so we can't do anything. Now, can this happen? You need to make a draft model agreement from the buyer's point of view and say that every developer should have the following points minimum. See, you go and buy a tube light. What do you ask the person who sells the tube light? Kitne saal ka guarantee? You buy a mixer grinder. You ask the person kitne saal ka guarantee? You buy anything. You ask how much guarantee. You buy a house. Is there any guarantee in any of the agreement? As a technical person, I should say that if the column, beam and slab are of decent quality, not high quality, then the building should survive for 60 years. Forget 60 years, but at least 40 years it should survive. I have seen in Mumbai 12-year-old building coming up for redevelopment because the slabs are collapsing. So should there not be some guarantee in the agreement that if you take my flat in my building, then for 20 years there will be no waterproofing problem. If there is waterproofing problem, I will set it right. Then I will if there is structural problem in 40 years or 50 years, then I will set it right. Is there something like that which should be done or not done? But there is no such provision. So the RERA chief has this problem, but he cannot do anything. So he's suggesting amendments. So with the amendments, as and when the amendments happen, so we have, I'm a little impatient and I'm fed up with people of my generation. That's why I go to younger people. When the younger people understand the problem, the younger people have a better way of telling the powers that be that देखो भाई ये करो नहीं तो वोट नहीं मिलेगा. Once the politician knows that he is not going to get the vote, he will change the rules. And if he changes the rules, the community will benefit. So such amendments need to be taken. I hope I have replied to your question. Any other questions, please?
Yes. Thank you so very much, sir. That was the only question for you, sir.
Okay.
Thank you.
Thank you. And for all those who are attending today, if they have any questions, they can, your organizers can give my email address or so, and organizers can take those questions and send it to me. And I shall be happy to reply to all the questions, because questions are absolutely important.
Yes, yes. So there is a question,
Thank you.
but we'll take it up at the end because we have the technical session
You
too coming
have
up,
to
sir.
tell me, because it is likely that I have other commitments also. So you have to tell me when exactly I am supposed to field the question, so I can come online for that. Uh, because I will be
So
in and out of the
145.
145. Okay.
Oh, all right, sir. 145 will do. Yeah.
Yeah, 145 minutes. Thank you.
Yeah. Thank you. Thank you so very much, sir.
I hope
Thank you. Now it's time. Yeah. Yeah.
I hope the speech was enlightening enough.
Yes, sir. Very much. Very much. In
See,
fact, the students are thanking you
the,
on in the chat
the
box.
first speech of any seminar must be educative, enlightening, and provocative. I have ensured that I did all the three, so that people get provoked to come out with their suggestions.
Yes, raise their voice. Yes, indeed, sir. Quite a few students are even thanking you, sir. Like it's a very wonderful lecture, very good insight and all. So let me convey that message to you that it was a very enlightening lecture, sir.
Thank you.
Welcome, sir. Now let's move to the technical session 2. And to introduce our resource person, Dr. Santosh Kakade, who is a member of State Consumer Dispute Redressal Commission, Maharashtra, Mumbai. I would request and I would rather welcome Dr. Seamus Maria Goretti, ma'am, to come ahead and introduce the resource person, who is an assistant professor with VVMGR Kare College of Law. Thank you, ma'am. Over to you.
Thank you so much, sir. Good afternoon, everyone. It gives me immense pleasure and a proud privilege to introduce to you the second resource person for today's webinar. He is none other than Dr. Santosh Kakade, a self-motivated general trauma and orthopedic surgeon with over 20 years of practical experience in patient care and surgery. Dr. Kakre is a unique blend of surgical skills with legal knowledge and a vision to novel technologies that impact hospital management. Dr. Kakre has vast experience of cultivating successful and long-lasting interactions with medical professionals and hospital employees. He is associated with various institutions such as RST Regional Cancer Hospital, Nagpur, BGS Global Hospital, Bangalore, Ruby Hall Clinic, Pune, to name a few. Presently, Dr. Kakre is a non-judicial member of the State Consumer Dispute Redressal Commission, Mumbai. He has excelled in academics, having completed his studies in orthopedics and general surgery from Shivaji University, Maharashtra. He has also completed his law studies from Shivaji University as well
Ma'am, are you there?
afternoon. I would like to call on Dr. Professor.
There is some technical glitch. Ma'am, are you there? She's back. She's back. Yeah, yeah. Please.
Yeah, just a minute, sir. Please let me the link. Sorry for the technical glitch, sir. Let me continue from where I had left. Dr. Kakre has excelled in academics, having completed his studies in orthopedics and general surgery from Shivaji University, Maharashtra. Sir
Dear participants, with this new normal technical, we are more dependent upon the technical devices, but I'm extremely sorry for this glitch.
I suggest that we should go forward. We should go ahead.
Yes, sir. Yes, sir. Rather,
Spending much
I would
time
rather
on introduction.
request you. In it, sir. Then, as you wish, over to you, Dr. Santosh Kakre, sir.
Yeah.
We can start. We can start with the lecture. Yes.
That's a great decision. Thank you.
for the prestigious Award of Scholarship 2011 from the American College of Healthcare Executives.
Yes, so we
Absolutely fine.
can start.
Right. I think she is still talking. You can inform her.
Gaurati ma'am, please unmute yourself.
Yes, yes. I have
Okay.
before you Dr. Santosh Kakre, a man of international repute, who would be taking up the session titled The New Consumer Protection Act 2019 and Real Estate Consumers. Over to you, sir.
Thank you very much for lucid introduction. Thanks a lot.
Thank you, sir.
Now, as the corona has given us this good opportunity to interact with each other on virtual platform, we can say this has certain drawbacks also, like we are experiencing depending upon the availability of connectivity, but then it's fine. So good noon to all of you. At the outset, let me thank the principal of Modern Law College, Professor Adhav Madam, and the one who invited me, Professor Prajakta Madam. At the same time, this is a unique, I think, program in which two law colleges have come together. The principal of the Curry Law College, Dr. Professor De Silva, all the faculty of both the law schools, and the audience who is now present includes the law students as such. We have heard in absolutely clear language and concise language the previous eminent speaker, Mr. Chandrasekhar Prabhu. I'm thankful to him because in a very simple and lucid language he has explained what RERA is to all the students. In this particular program, there are two more speakers apart from me. The first one is the recently retired former senior most judicial member, Shri P.B. Joshi sir from the State Consumer Commission. He also will be enlightening you. And the Consumer Courts Advocate Association's President, Advocate Dr. Varun Jikar will be addressing to this particular session. I will be talking about the Consumer Protection Act. I think as a student, probably the senior students will know about the Consumer Protection Act 1986. After enactment, since last 34 years, there have been a number of changes which have taken place, and all the changes have incorporated in the new act. And you are probably aware that the new act, the Consumer Protection Act 2019, has come into existence. It was implemented on 20th of July 2020. Now let me inform all of you, in whole of the consumer system, which comprises of three-tier system, the district commission at a district level, state commission at a state level, and national commission, that is National Consumer Disputes Redressal Commission.
काकडे
Oh,
कशासाठी
hello, am I audible?
yes
Okay. So it's a three-tier system in the consumer court, in the consumer act, which is taking care of the overall consumer matters as such. So the majority of the consumer matters belong to the real estate. That means the cases against the builders. So they are filed and they are decided. So up till now, even before the advent of RERA, the consumers, aggrieved consumers, which were aggrieved from the builders and flat purchasers, they are approaching consumer courts, and they are getting relief under the Consumer Act. In short, I'm going to tell you about the existent Consumer Protection Act. So what are the changes that have taken place from 1996 to 2019? I'll be very brief. I'll be showing you a presentation. So let me share my screen now. I hope all of you are able to see this.
हो गया ना ये क्या है हाँ आ रहा है
So the Consumer Protection Act 2019 and the real estate consumer. The Consumer Act has specifically defined who is a consumer. The consumer is a one who buys some product or hires services for some consideration. It's a simple language. It is simple definition in a simple language. The consumers, they are protected by certain rights which have been given to the consumers by the act itself. There are totally eight rights which are given to the consumers, and out of which 6 rights are enforceable under the Consumer Protection Act. Now, to understand who is a real estate consumer, So as obviously it was discussed, the real estate consumer is none other than the one who purchases flat and or some real estate. So he is a real estate consumer. Now we are going to, in a short, going to look into this particular aspect, whether real estate consumer is covered under the new act or not. So as I have already mentioned, the Consumer Protection Act 2019 applied from 20th of July 2020, and some of the provisions were applicable on 24th of July 2020. Thus, the old Consumer Protection Act 1986 was repealed. The present act has major changes. So number of sections are increased. I'm going to come to that in next slide. So as it was discussed, whether real estate has been covered in that. So whether it is applicable to the real estate matters, because we all are aware that now RERA is the act which is taking care of the consumers, rather flat buyers, flat purchasers as such. In short, the Act of 2019 is 35th Act of 2019. It has 107 sections. The previous act was having 31 sections. So there has been an increase in the number of sections, as this present act is elaborately discussed and elaborately defined. And in the act, the authorities have been increased. This has given more tooth, we can say, to the consumers. There are 8 chapters in this particular act. So the first one, as usual, is a preliminary, which gives the definitions. Various definitions are elaborately mentioned, and I'm going to mainly stress upon the unfair contract and unfair trade practice. Of course, in due course of time, I will discuss about that. Consumer protection councils are the councils which are having role of advisory nature. Third chapter is Central Consumer Protection Authority, so CCPA. It's a new introduction. Fourth chapter is Consumer Disputes Redressal Commission, which was right now discussed by me, that there is a 3-tier system. Mediation, a new introduction into the Act of Consumer. That means every consumer matter should be referred to mediation. We will come to the details at some certain point of time. Product liability, again a new introduction to this particular act. Offenses and penalties are discussed under chapter 7, certain miscellaneous provisions under chapter 8, and the special introduction is of the Consumer Protection E-commerce rules 2020. That means nowadays there has been an increase of online buying and purchasing things, and the consumers who are buying online products, they are protected by these rules. Now let us come to the Consumer Protection Councils. So these councils, the provision was there in the old act. Now new act also there is a provision. It's again a 3-tier system, we can say. Section 3 to 9 cover that Consumer Protection Council, the members, and what is the provision for the functioning of Consumer Protection Councils have been given, and in section 3 to 9 there are 3 central Consumer Protection Councils, state level and district level Consumer Protection Councils, and as already told, they have advisory role. So advising the government on various consumer protection aspects is the role of Consumer Protection Councils. Next chapter, which is a new introduction, you might have read or heard about CCPA, that is Central Consumer Protection Authority. Sections 10 to 27 cover this Central Consumer Protection Authority. By this, there is a new powerful mechanism in which there is a chief commissioner and other commissioners who are appointed. They have a power to take so much action against those who are those service providers or those manufacturers who are at fault. it has an investigation wing. As I already told, the central authority has been given more powers, and the functional autonomy has been given to the CCPA. The role of district collector again is defined under this authority itself, that the consumers can also approach the district collector and can request for action against the uh, those who are, we can say, at fault. There is a provision of appeal. Though it is a national level body, the appeals against the decisions of the Central Consumer Protection Authority can be made at National Consumer Disputes Redressal Commission. So that means it has a equivalence of the State Consumer Commission as such. Sections 28 to 73 define elaborately details of how the consumer disputes redressal commissions at three levels are formed, who are the members, how what is the functioning, and how this relief to the consumer should be provided. The changes are, instead of a forum, it is known as a commission now. There is a change in the pecuniary jurisdiction, and there are two main important changes in the pecuniary jurisdiction. The first one is, previously under the old act, the district forum had the pecuniary jurisdiction of matters of value up to 20 lakh, from 20 lakh rupees to 1 crore. The state commission used to have the pecuniary jurisdiction, and above 1 crore, it is National Consumer Disputes Redressal Commission. Now this has changed to the higher, we can say, values. So pecuniary jurisdiction has changed, that the matters having the value of 1 crore, they are now dealt by the District Consumer Commission, from 1 crore rupees to 10 crore rupees by State Consumer Commission, while the matters having pecuniary value above 10 crores are dealt by the National Consumer Disputes Redressal Commission. So this is the first change which has taken place. The second change is, previously the claim which was made by the complainant used to be considered as the basis for considering the pecuniary jurisdiction. Now it has changed to the consideration paid. That means whatever may be the amount or the value of the products or services, whatever amount that consumer pays, that is considered. If it is below 1 crore, it goes to the district commission. So finally, what is happening or what is going to happen is, almost majority of the consumer cases now will be going to the district consumer commission. The state consumer commission has appellate jurisdiction. Within 45 days of the district commission's decision and the order, the aggrieved party should come to the state commission, while against the orders of the state commission, within 30 days, the aggrieved party can approach in appeal to the National Consumer Disputes Redressal Commission. Now, there has been a change in the territorial jurisdiction. What is this change? Previously, the territorial jurisdiction used to be decided by the opposite party's, we can say, location. So at least an office, or at least say branch office, if it is there in that particular place, the consumer case could have been filed at that particular district forum. But now there has been a change, and now it is based on where the consumer resides, or where the consumer stays, or where from the consumer is. Now, so anybody who is a consumer who suppose buys certain thing or hires services from anywhere in the country, but if suppose he is from Pune, then he can file complaint in Consumer Commission, District Consumer Commission of Pune itself. So let the opposite party come to this particular commission. So this is the change in the territorial jurisdiction. Another change is that the matters who are filed in the consumer commissions, they are deemed to be admitted after 25 days. So this rule is now going to decide, or this section is going to decide now that all the matters will be admitted within 21 days, and this will help in deciding the matters as early as possible. Another additional information is that the review powers which were previously not there with the commissions have been given. Only National Commission was having the review power. Now all the three, that is district, state and the National Commission, has been given the review powers. That means they can review their own orders by on application of the affected party. So it's a again an additional modification and a good change which has come out in the present act. Another new introduction is mediation. Mediation is nothing but trying to settle the matter even before it comes before the commission. So section 79 to 81, they are dealing with the mediation, and the provision for mediation is that there will be establishments of mediation cells at all the three levels, and the matters from the consumer commission, they will be initially referred, of course by the consent of the both parties, to the mediation cell, where the dispute resolution will be tried by the use of mediation. And I am not going into the details of mediation. I think those who are studying mediation will definitely know that mediation is a process where both the parties come together and they accept certain settlement. Once the matter is settled in the mediation and they have accepted, they cannot, no party can again appeal against this mediation acceptance of the mediation decision. And when this is based on the mediation, when the commission disposes this matter, no appeal lies against this particular accepted decision. So this is additional we can say provision. So finality of the mediation proceeding and settlement. So this is what I have already explained. And another new important chapter is product liability, sections 82 to 87. The liabilities of product manufacturer, liabilities of product service provider, and liabilities of product seller, they have been defined. Obviously, the product seller has less liability, but the manufacturer and the service provider, they have higher liabilities. And this chapter defines and discusses about or gives provisions about how product liability is to be fastened and what are the legal provisions to take actions. Very important. This is chapter 7, offenses and penalties, sections 88 to 93. The penalty has been defined for non-compliance of the orders of the commissions. Then also the penalty for misleading advertisements. The classic examples are the renowned, we can say, cine stars or cricketers or whatnot. So many, they are involved in advertising various products. In a lighter mood, we can you might have gone through the WhatsApp messages that whenever Mr. Saurav Ganguly advertises that particular oil, when he suffered from the angina and had a cardiac problem, there were messages that whether this oil itself was useful to him or whether this has caused the cardiac problem to him. So this was a lighter mood. So whenever misleading advertisements are there, suo motu, the action will be taken under this particular act. Especially the products with adulterants, there are very strict provisions made under this section, the offenses and penalties. The conviction up to 3 years and the fine up to 50,000 rupees is mentioned. At the same time, if the adulterant, the products with adulterants are found, the fine can be up to even 20 lakh rupees for misleading advertisement. The suo moto action can be taken against that particular advertising person, and rupees 10 lakh or 20 lakh fine can be actually asked him or her to pay for. Similarly, spurious goods, very strict action is taken against the spurious goods. Now, the last thing is the new introduction of e-commerce rules 2020. As we have already seen, the online purchase of products by the products which are sold by various online agencies and companies, if there is an unfair trade practice in that, and if the consumer is we can say consumer gets some alternative products, or there is an unfair trade practice during these particular online transactions, the e-commerce rules have been elaborately defined to decide duties of commerce entities and liabilities of marketplace and e-commerce entities. So this is a new introduction. I think the interested students should go through these provisions, and the act is available. I'm sure you will definitely get more and more knowledge from that. We have already discussed about the territorial jurisdiction, what are the changes, new changes have come in place. Another important thing is that the whenever appeal is preferred against the decision and the order of a lower court, lower commission, one has to deposit at least 50% of the decretal amount in the appellate court. Regarding mediation, this is specifically mentioned that in case of medical negligence matters, there will not be mediation. So these matters will not be referred to mediation as such. About CCPA, we have already discussed. As I have already told before, the terms of a contract may be unfair, which can be declared as unfair by the Consumer Commission. So this power has been given under this particular new act, and these are the changes. Now this last one is the e-commerce, that is even video consulting by patients of a doctor comes under this particular e-commerce. So this is also a very important step, we can say. So while discussing regarding unfair contract and unfair trade practice, in the first chapter itself, section 2, the section 46 and 47 give the unfair contract and unfair trade practice definitions. I think you should go through. Mainly, in a nutshell, we can say the scope of these two important aspects have been elaborately increased. As I have rightly mentioned, that any contract, if suppose if it is unilaterally drafted, the commission can declare that this is unfair contract, and thus in the further litigation that uh, that can be considered as unfair trade practice. And unfair trade practice section 2 subsection 47 has given elaborate discussion and definition of unfair trade practice as such. Now I am coming to an important Supreme Court judgment which was decided and declared on 2nd of November 2020. Means recently this was discussed, and we can say the order was passed. So the case was Messrs. Empiria Structures Limited versus Anil Patni and another. Now, the appellant tried to discuss, or it put forth in the Honorable Supreme Court, that since RERA is there, the home buyers cannot pursue remedies at consumer fora. So this was the we can say a say of the appellant as such, as it was an appeal against the order of the National Consumer Disputes Redressal Commission. The two-judge bench of Honorable Supreme Court has given this judgment and the decision that despite RERA, the home buyers can pursue remedies at consumer forum. So home buyers can still approach the consumer forum, including refund and compensation from such companies for delay in handing over possession of their dream homes. So this was the order which was given by Honorable Supreme Court. In the same judgment, it is mentioned that the RERA Act does not bar remedies under Consumer Protection Act. So Section 79 of RERA does not in any way bar the National Disputes Redressal Commission or Consumer Forum, means now any commission under the provisions of Consumer Protection Act from entertaining any complainant. So in a nutshell, the home buyers can approach consumer commissions for additional reliefs under the Consumer Protection Act. So this is, I think, a take-home message. So right now, very briefly, I have given some information about the new Consumer Protection Act 2019. It is an expanded version giving more power to the regulatory, or we can say the authorities, and giving in a way it's giving more support or more rights to the consumers who are aggrieved from various products, faulty products we can say, or the unfair services. So thus, considering the real estate consumer can still approach the consumer courts, there is the consumer commissions for relief, as the Consumer Act has these provisions of declaring the contract as unfair as well as the deficiencies in the services, and then awarding compensation and even ordering the opposite party builders for not only the corrections but the compensation is being awarded. So I think with this, let me stop here. Being students of law, I think you should get interested in the Consumer Act as such, and there is a huge scope, let me tell you, with the advent of this new act, while helping the consumers in the consumer court system, that in the various commissions as such. So with this, let me stop here, because we have a very eminent person who has, or we can say a senior most our member who is a recently who has become former, I can say, uh, senior judicial member, Mr. P.V. Joshi sir, is available, so he will be enlightening us more. So let me thank the principal and of principals of both the law colleges and the organizers for inviting me for this particular seminar. Thank you very much.
Thank you, Dr. Santosh Kakade. You have really given us a brief overview of the newly enacted Consumer Protection Act of 2019. You have also highlighted a lot of legal inputs as well. Hope all our listeners have benefited immensely from the same. Thank you very much. I now request Mr. Pavan to kindly take over.
Thank you, ma'am. Now it's time for our the next session. That is, we'll be introducing the third resource person. As rightly Dr. Kakde has mentioned, we'll be introducing Honorable Shri Pradeep Joshi sir. He was a practicing advocate at Aurangabad High Court for a few years. Thereafter, he joined judiciary in the year 1982. He worked as a principal district judge from 2007. Sir has worked as a member of State Consumer Dispute Redressal Commission, Maharashtra, Mumbai since 2014 to 2020. So Sir has an immense experience. Sir has also worked with the charity commissioner as a charity commissioner of Pune. Sir is having a vast experience of deciding consumer matters related to real estate. So herein I welcome Honorable Shri Pradeep Joshi sir. Sir, over to you. You can start with your presentation.
Hello everybody. all the dignitaries present and the students. Whether I am audible?
Yes, sir. Yes, sir.
Oh,
You're
oh.
audible. Yeah, yeah.
Today morning itself, when I had a talk with my friend Dr. Kakade, he informed me about today's webinar, and I told that I will come and I will hear that. But he requested me on behalf of the organizer to participate it in. And on his request, I accepted it. As such, I have not prepared anything for this webinar today, specially. However, as I have worked for so many years in judiciary and the consumer fora, I will make some submissions on today's subject. Real estate appears to be the main subject for today. Initially, the housing construction was not included within the definition of service in Consumer Protection Act 1986. However, by way of amendment, it was included in the definition of service, and then all the flat purchasers or flat buyers became the consumer under the Consumer Protection Act. And now that definition continues in new act also, and even under new act, all the flat purchasers are the consumers under the Consumer Protection Act. As most of the matters pending before the consumer fora are in respect of the real estate, and hence when we can say that the main object of the act is to provide relief to the flat purchasers. As explained by Dr. Kakade, by way of amendment in pecuniary jurisdiction, now most of the matters will be filed before the district forum, as they have a jurisdiction up to 1 crore. However, the definition is that the consideration paid that will decide the jurisdiction of the forum. It means if anybody has agreed to purchase a flat for more than 1 crore, say for 1 and 25 lakhs, 1 crore and 25 lakhs, and if he has paid part of the consideration less than 1 crore, and he has to approach consumer fora at that stage, then he can approach the district forum as the consideration paid is less than 1 crore. If, however, because of these provisions, there is some anomaly. Say if in one building, two friends have booked a similar flat for similar consideration, say for rupees 1 crore 50 lakhs, and one has paid 95 lakhs rupees as part of the consideration, and another has paid 1 crore and 5 lakhs as part of the consideration. And if both have to approach the consumer fora, then one will approach to district forum as he has paid only 90 lakhs rupees, and then it is within the jurisdiction of the district forum. However, the another friend who has paid rupees 1 crore and 5 lakhs, he has to approach state commission, as the jurisdiction will be with the state commission, as consideration paid is more than 1 crore. The the concerned persons have to see how this anomaly can be removed. As I have said, most of the litigation before the district forum and even in all the commissions are in respect of the real estate. That is the dispute between the flat purchaser and the builder. In fact, by filing the consumer dispute about the real estate or getting the possession of the flat, this is like a specific performance, as there was an agreement between the parties to give the flat against the consideration to be paid. This is like a specific performance, and this remedy was available even before the civil court. However, for approaching the civil court, strict rules of evidence were to be adhered to. That is not the position here in this commission and under this act. Even there is no specific agreement between the parties, and if some amount is paid as a part of consideration for any flat to be purchased, on that basis also the person purchasing or agreed to purchase the flat can file a consumer complaint, as he becomes a consumer of a builder, that is a service provider. This is a service, and their builder is a service provider and purchaser is a consumer. What was the necessity for enacting the Consumer Protection Act when the remedy was available in the civil court? It was thought that in civil litigation it will be lingering for years together, and the consumer must get a relief within a reasonable time. Even in the act, a provision is made that the consumer dispute be decided within 90 days or at the most within 5 months if the sample is to be referred to the laboratory. However, we all are noticing that it is really impossible to decide the matter within 90 days. What is the reason? The reason is that it is not seen anywhere. No arrangement is made for to see what is the pendency of the matter before the fora, what is the inflow of the litigation, and what is the expected disposal by any fora. The number of the fora should be proportionate to the inflow of the litigation. By way of different programs of awareness of consumer rights, more and more consumers are approaching the consumer fora for getting their rights, and it is because of that there is flood of litigation before the consumer fora, especially about the real estate. If that is so, then the number of forum must be proportionate to the inflow and present pendency and the capacity of or expectation of the disposal of the matter by a fora. This is not seen anywhere. No program is made for that, and in spite of that, how we can expect that the matter should be disposed of within a particular period. That cannot be. And hence it is necessary for the concern to see that the number of the fora or the members in the fora or in the commission must be proportionate to the inflow of the litigation, and then only we can expect that within a reasonable period, the matter can be disposed of before the consumer fora. Unfortunately, we have seen some litigation where the flat purchasers have filed a complaint against the builder as the construction was incomplete condition, and the matter was lingering for so many years that the time has come to demolish the said structure and to rebuild the building. This is a very bad situation. However, it is only because the members in the commission or the number of the fora is not proportionate to the inflow of the litigation before the fora, and this, if it is not considered, then the consumer will not get relief within a reasonable period. So this is very important thing is to be noted by the concern. Now I have retired in December. My colleague has retired in October. Our president retired in September. However, till today, nobody is appointed on our vacancy. So it is necessary for the concern to see that the list is prepared of eligible person to appoint on the vacancy which will be created in future, and as soon as anybody retires, another person should be appointed on his place, so that there should not be any gap. There should be a gap for continuation of the process, and it is very important. And I request all the concerned to see that this should be done, and then only, and by giving a proportionate number of members in different fora or sufficient number of the district forums in proportionate to inflow of the litigation, then only the consumer will get a proportionate within the relief within a reasonable time. Just now my friend Dr. Kakade has said that now, because of the increase of the pecuniary jurisdiction, most of the matters will go to district forum, and hence it is necessary to increase the number of district forums so that the consumers will get a relief within a reasonable or expected period of time. And it is for the concerned authorities, it is for the state government to see that this situation should come, so that the consumer should get a relief within a reasonable time, and the object of the Consumer Act will be fulfilled. With this, I close my speech.
Thank you so very much, sir, for explaining the internal working of the commission, as well as expressing your views and your suggestions for the improvement. And more importantly, you are more interested in giving justice to the consumers. So thank you so very much, sir. And I also understand your plight that when the vacancies are made, no one is appointed on those positions, and that is hampering, and that is hurting the consumers at large. Thank you so very much, sir, for your enlightened speech. Now it's time for the last session, last technical session. And we have a renowned lawyer from our High Court, Mumbai, Dr. Uday Varunjekar, sir. And to introduce Dr. Uday Varunjekar, sir, I request Assistant Professor Ruchira Nayak from GR Kare College of Law, Goa, to take over and introduce our last resource person.
Thank you, sir. Am I audible?
Yes, ma'am.
Yes. A very good afternoon to everyone. We have with us our next resource person, Advocate Dr. Uday Varunjikar, who will be speaking on the topic New Dimensions of Housing Laws. Dr. Uday Varunjikar has been awarded PhD degree from Savitribai Phule University at Pune in the year 2019. He has been practicing in the High Court for more than 26 years and has handled more than 14,500 cases in High Court and also successfully handled various public interest litigations in a variety of fields such as rights of persons with disabilities, implementation of biomedical rules, environmental pollution, and unauthorized construction, etc. Dr. Uday Varunjikar has authored two Marathi books relating to legal matters, which are also translated to English. He has also addressed the public on various legal issues through TV channels, All India Radio, and has been a regular columnist in local dailies. He has participated in various international conferences in India as well as abroad. He has been invited as a resource person both at national and international events. He has also headed different bodies in the legal field. He is also recipient of the award from Mumbai Grak Panchayat for valuable contribution in protection and promotion of consumer rights. With this introduction, I welcome our resource person, Advocate Uday Varunjikar, for this national webinar, and I request him to kindly take over the session. Over to you, Sir Uday Varunjikar.
Namaskar. It's a pleasure to meet all my friends who are on that side. The new year had started, and this new year we were expecting that we will not meet in this manner. However, it seems that few more months the same situation will be there. Now, having said about this, I must also mention my special thanks to the team of both law colleges. The concerned professor, for whatever reason, omitted to make a reference about the regulatory body, namely Bar Council of Maharashtra and Goa. Being an elected member of
Sir, please unmute yourself. Yeah, thank you.
I was muted by the host. I hope that there won't be such attempt in till my completion of my this session.
Extremely sorry, sir.
Since I made a reference that the introduction of the speaker was inadequate, so therefore I made a reference to the a member of a bar council, a elected member is there who is having a regulatory authority. I am sure the law college where the concerned speaker was there or that professor was there must have faced inspection from the Bar Council of India, and the member of the Bar Council of Maharashtra and Goa will be there. So therefore, I'm sure she will remember what is to be deleted and what is to be shared with the professors. Anyway, let us come back to the track. New dimensions of housing laws, that is the topic which is assigned to me. Now we have seen there are three such speakers. One, Prabhu sir, who pointed out that The enactment is already there, namely the RERA Act. He pointed out what are the shortcomings. Then the second is Dr. Santosh Kakreji, who is Honorable Non-Judicial Member of the State Commission, Maharashtra at Mumbai, who gave an insight of both the act, namely the old act, new act, and the remedies which are available. Then the retired judicial member P.B. Joshi sir was also there, member of the State Commission he was. And I am fortunate that I had appeared before him on multiple occasions. I have assisted him. And it was a pleasure arguing before Honorable Justice P.B. Joshi, the retired judicial member. And it is a pleasure to appear and assist in a matter before Honorable judicial member, non-judicial member Dr. Kakre. Now, since three speakers have already shared their views, now I choose this topic, and then let us find out what are the new challenges and what are the new dimensions of this field, namely housing law. I am aware that the topic is about the real estate. However, the real estate terminology is defined for the first time in the RERA Act. And I am sure those who are interested, they will go to the Google Mausi. I am aware the Google Mausi, which is there in your smartphone, she is there to assist you all the time. So therefore, those who are interested, they can go to the BEAR Act by typing the RERA Act, and you can get the real estate terminology which has been defined by the legislators. Though it has been defined, I am going to take back you back to the framework of the Constitution. Let us go back to the framework of the Constitution. In 1950, we accepted our Constitution. We adopted our own creation of a framework of the law, and that has divided certain topics which are known as central list, state list, and concurrent list. In the 7th schedule, we find all these three lists. Since we are dealing with the housing, so therefore let me point out, those who are interested, they can note down. So far as the state list is concerned, there are two entries. Entry number 18, which is about the land, and entry number 45, which is again concerning the land but from a different angle. So there are two entries, entry number 18, entry number 45, which are relevant to the today's this webinar. As a student of law, we can't ignore the basics, namely the foundation of this real estate in the framework of the Indian Constitution. Apart from this, if we go to the concurrent list, there is entry number 7. That entry number 7 gives a right or gives authority or gives a power to the central as well as the state government to enact the law. And that is with reference to the contract excluding the agricultural land. So therefore, those contracts which are dealing with the real estate or housing are covered under this entry number 7. Having said about this, I am going to refer about the different such legislations which are in the field. But since I am making a reference to the Constitution, I thought it fit to conclude this topic by making a reference to certain few other articles. We are aware that there are fundamental rights, and all my law students who are on that side, they must have studied this topic. And therefore, whosoever who is interested, please write down Article 19(1)(e). I'm sure you must have seen this article or read this article on multiple occasions, but it is a time when I'll have to read about that. Now that is 19(1)(e) says it's a fundamental right to reside and settle in any part of the territory of India. So two keywords. One is reside and settle. Why these two keywords are necessary for today's session? Because we are dealing with the housing law, we are dealing with the real estate as a segment. If we are considering the real estate as an industry, then this fundamental right under 19(1)(e) to settle and reside gives a right to some kind of a right of shelter. I'm going to refer to those judgments, few judgments. There are series of those judgments which have been delivered by the Honorable Supreme Court of India, which has expanded Article 21. But before making a reference to that, I must also make a reference about the DPSP Article 47. I am aware that you must have been taught about this word DPSP, Directive Principles of State Policy. And Article 47 contemplates a duty of the state to raise the level of standard of living. Since we are dealing with the topic of real estate, which is having a direct nexus with the standard of living, and housing is also having a relation with standard of living. So I made a reference to DPSP. So therefore it's a corresponding duty of the state government as well as the central government. However, we are aware that DPSP can't be enforced like a FR. But still, in last few years, the new dimensions which I am making a reference are coming into picture. There are a series of judgments which are converting DPSP into FR. Yes, you are right. Though DPSP, Directive Principles of State Policies, can't be enforced as a fundamental right, the Honorable Supreme Court has started deviating that principle, and now Directive Principles of State Policies are sought to be converted into a fundamental right by virtue of a judicial interpretation. This is that new dimension. The new dimension has been seen for years together, and coming about this particular topic about the housing, let us go back long back in 1981. There is a judgment of Francis Corley versus Union Territory of Delhi. Those who are interested, they can find out on Google Mousy what are the citations. I will not trouble, because in the flow there is no need to point out what are the page numbers and which are the citations. Or if we go back to 1996, UP Awas Evam Vikas Parishad, that's one of the milestone judgment where the Supreme Court said that a right to shelter is included in Article 21. So therefore, from 1981, slowly, the Honorable Supreme Court started expanding the scope of Article 21, and now in 1996, it expanded it further by saying that in the UP, Uttar Pradesh Awas Evam Vikas Parishad judgment said that shelter is one of the fundamental rights. Let us go back to the another judgment. Those who are interested, they may note down Chameli Singh versus State of Uttar Pradesh, 1996, another milestone judgment. In this judgment also you will find the Honorable Supreme Court expanded the scope further, and this DPSP is converted into FR, and now it is brought within the framework of Article 21. Having said about this 2-3 important judgment, I can't forget about Olga Tennis. Long back in 1985, during that phase of expanding the scope of the Article 21, even the Supreme Court of India delivered a fantastic judgment, Olga Tennis versus BMC. So therefore, these are the few judgments which have expanded the dimensions of the housing or a real estate as such. If we are going to trace the history of the development of the real estate in India or housing laws in India, then we can't ignore these judgments by virtue of which the new dimensions have been introduced by virtue of a judicial pronouncement. There are two more articles in respect of which I wish to mention. We are aware that there was a right to hold and acquire property, which was one of the fundamental rights, and the Parliament has thought it fit to amend the Constitution, and that 19(1)(f) has been deleted. Now it's one more challenge and a topic which will require a further debate, maybe a legal debate, whether the time has come for reintroduction of a modified version of a fundamental right to hold and acquire the property. Nonetheless, after this 19(1)(f) was removed, Article 300 capital A came. That was an amendment in 1978. That 1978 amendment was 44th constitutional amendment, which says that any person cannot be deprived of his property save by authority of law. So this is an assurance which is under chapter Roman 6 of the Constitution, which is the new chapter, again a new dimension, which is given in 1978. And right or wrong, our lawyers have not taken this further, nor the honorable judges have taken this further to the logical aim. No doubt, in few judgments there is a reference about Article 300 capital A, but still best is yet to come. That is my personal view. Having said about this constitutional framework, let me take back all of you to the legislative framework which was there and the new things which have been introduced in the recent past. Let us go back to Indian Contract Act 1872. In the British regime, this act was enacted. We are aware that even in the real estate there is a contract. So therefore, the all principles of a valid contract are involved in the actual this kind of a transaction. So therefore, Indian Contract Act is the basis of the real estate transactions. But Indian contract is not a full stop. We are aware about the terminologies like offer, counter offer, consideration. All these terminologies are aware. Enforceable by law. What do you mean by enforceable by law? Contingent contracts, quasi contracts. We are aware, as a law students, we have heard this. But that is not enough for so far as the real estate is concerned. Transfer of Property Act 1882 is another specific piece of legislation which deals with sale, section 54-55. Sale, exchange, gift, lease, mortgage. We have heard about these terminologies, but these terminologies are defined within the legislative framework of a Transfer of Property Act 1882. Apart from that, there is another enactment of the same year, namely the Easement Right. So Easement Act 1882. There are some easementary rights which are attached to that particular plot of the land. So therefore, there is a separate legislation which has been framed, which has been enacted during that British regime, but still that legislation is applicable today. And while dealing with the housing laws or the real estate sector, easementary right is also one of the important aspects. So those who are interested to know what is the meaning of the word easement, what are the types of the easement, surely make a reference, go to the library, find out the BERAC or get a small commentary on this. Now, having said about this British regime legislations, let me take all of you back to 1947. In 1947, Bombay Rent, Hotel and Lodging House Rates Control Act 1947 was enacted. Like the generation of the advocates like Honorable ex-member P.B. Joshi said, he must have fought several legislations arising out of this Bombay Rent Act. Even my generation, we were also having the old matters which were filed under that act, which were pending for years together and came before the Honorable High Court. So therefore, we are aware about the Rent Act provisions of 1947 Act. But this act was essentially enacted with a view to control and regulate the rent. So therefore, it is having a very limited impact so far as the housing is concerned. It was pro-tenant, which was developed by virtue of the various judgments. There were several safeguards which were given to the tenants. The act was enacted during that period when there were no such houses which were constructed, and therefore the act was enacted. But slowly the act was interpreted to give a protection to the tenant. Now, there is again deviation. The Maharashtra Rent Control Act 2000 came, and from the tenant protective angle, the angle was shifted to the new dimension was added around 20-21 years back, and that is pro-landlord legislation came. That is the Maharashtra Rent Control Act 2000. Despite this, now there is one more new legislation which is in the pipeline. In the year 2019, when the finance minister was giving a budgetary speech in the Parliament of India, at that point of time, a statement was made about introduction of the Model Tenancy Act. The draft was introduced. Last year, of course, there was no such development due to pandemic, but the parliamentary committee has sought our suggestions and views on Model Tenancy Act. The draft was referred to the parliamentary committee, and that parliamentary committee has invited all of us to give our views on this Model Tenancy Act. This Model Tenancy Act will be again one more deviation, and they are trying to balance both the things. The earlier legislation was pro-tenant, then pro-landlord, and now the new legislation which is sought to be introduced is Model Tenancy Act. As a member of a bar council, in the last full house, we as Bar Council of Maharashtra and Goa passed a resolution constituting our study group to study this Model Tenancy Act, and very soon we will be giving our suggestions. So therefore, all those young students and the professors who are on that side, if they are interested, they can give their views to the Bar Council of Maharashtra and Goa, or to the organizers. Organizers may forward it to me, and I can table it before the study group of Bar Council of Maharashtra and Goa, and we can give our suggestions to this draft Model Tenancy Act. This was with reference to the tenancy, but in 1963, a new concept was brought by the legislators, that is about the flat. What was the concept prior to that? Prior to that, it was a house, it was a wadi, it was a room. But a new concept came to be introduced in the year 1963, and that was a legislation by name Maharashtra Ownership Flat in bracket Regulation of Promotion of Construction, Sale, Management and Transfer bracket Complete Act 1963. We as a lawyer call it as a MOFA. The name is MOFA Act 1963. It introduced such a change that in the urban area, several new concepts were introduced, like the promoter, like the concept of a flat, the definition of the flat. The definition of the flat was expanded to include even the garages, godowns, industrial establishments, all were included. There were duties of a seller or promoter, there are duties of a purchaser. There was a corresponding provision about the passing of the title. There were criminal offences which were also provided under the Act. After a particular point of time, no change in the plan. That was also one of the important sections. Section 7 was introduced. Section 7A was an amendment which was again introduced thereafter. This was about the MOFA Act. But unfortunately, MOFA Act resulted into creation of such a remedy which was not speedy. What were the remedies? There can be a criminal case before the magistrate court. There can be suit for the purpose of conveyance or getting the passing the title of that entire property. And after introduction of 1986 Act, namely the Consumer Protection Act, those cases under the MOFA Act, they started coming under the umbrella of Consumer Protection Act because the terminology was word services. The definition of the word services includes housing, and therefore this was brought under the purview of the Consumer Protection Act. But still there was a second thought, and therefore Maharashtra Apartment Ownership Act came in the year 1970. You must have heard the word condominium. You must have heard the word apartment. So these are the two things which were brought by way of a separate legislation. Now the citizens as well as the student of law, they started making a comparison, which is better. A flat is better or apartment is better. Whether we should go under the MOFA Act or whether we should go under the Apartment Act. So that to minimize this confusion, again MOFA Act was amended. And whatever may be the apartment or the condominium which is declared under the Apartment Act, that was brought under the control of MOFA. So therefore again there was a deviation. Now it's a time which has come to find out whether this Maharashtra Apartment Ownership Act 1970 requires a further day of light, whether it is required to be repealed in view of the RERA Act, whether now MOFA Act is virtually there are no litigation with reference to that, and in view of that, whether now it's a time to say go by or goodbye to the Maharashtra Apartment Ownership Act. Now let us go back to the Maharashtra Cooperative Society Act. That's the 1960 Act. And there was a consistent demand that with reference to the housing societies, there is a need for a separate piece of legislation. There were ordinances after ordinances by virtue of which the state of Maharashtra was pleased to introduce a separate chapter dealing with the housing societies. And now ultimately in 2019, a new chapter has been introduced which deals with the housing societies. So therefore, those students who are having an interest in this real estate sector, they will have to understand it's a new legislation, new chapter, and you will have to master over that chapter also. Having said about this, I must mention about three new different types of the legislations which are already in the field, which are having a direct nexus with the housing or the real estate. That is a MAR Act 1976. I am having a very proud feeling that from 1996 I was a panel member, sole panel advocate of a MARA for sufficiently long period. MARA Act is having one of the object with reference to a maintenance of the buildings and the repairs and reconstruction of the buildings on the Bombay Island. Under the MAR Act, there are 9 separate boards which have been established. One of the board is Mumbai Housing and Area Development Board. There is like similarly Pune Housing and Area Development Board. So this is concerning about the housing. But MARA Act contemplates that MOFA Act will not apply. Now there is again a deviation. Now this is again a one more challenge whether that provision which was made at that point of time, whether it requires a further amendment, because now MOFA is virtually replaced by virtue of a RERA. So therefore RERA is attracted, not attracted. These are the things which are required to be considered by a student of law who are on that side. On the same line, there is a CIDCO Act. We are aware that CIDCO is a special town planning authority under the MRTP Act, Town Planning Act. And CIDCO has expanded their wings by introduction of the housing projects. Not only housing projects, they are in the field of allotment of the plots. Apart from the infrastructural development, they are providing the commercial plots also, housing plots also. So therefore, that's one more legislation. Whether that should be brought under the purview of RERA, that's one more thing which will have to be considered. SRA, Slum Rehabilitation Authority, established under the Slums Act 1971. Now since the college, one of the organizer college is from Pune, so therefore let me tell you, the SRA was a popular in Mumbai, SRA is popular in Mumbai, but now for Pune and Pimpri-Chinchwad area, there is a Slum Rehabilitation Authority. Very soon we will be coming across different such schemes in Pune about the slum rehabilitation. Now slum improvement, slum removal, these are the objects. And as a student of law, I must tell you the object of this 1971 enactment is a fantastic. And we are very proud that this 1971 enactment of the Slum Act has been followed by different South African countries. African countries have adopted the framework of the Slum Act. We are usually not aware about this. Something interesting, Consumer Protection Act 1986 was enacted by the India, and India became the first such country in the world who enacted a separate piece of legislation on the consumer after the convention was signed. We as a student of law, we should be proud of our own India. Now coming back, let me come back to the different such legislations. But now the moot question is whether the RERA or the consumer, which is better. And for that particular purpose, let me tell you who are the different stakeholders in the real estate. Of course, the developer will be one of the person who will be one of the stakeholder. So far as that stakeholder developer is concerned, he can't approach under the Consumer Protection Act, but developer is permitted to apply under the RERA Act. So a builder developer can seek relief under the RERA Act. Take a case, I'll give an illustration. Some flat purchaser or a purchaser of a shop is not coming forward for execution of the agreement, or is not coming forward with the balance payment of the consideration. Then what is the existing remedy if RERA is not there? That builder developer will have to go and seek a declaration and an injunction from the civil court. Till that point of time, there will be a blocking of the assets. So RERA has opened the door for the builder developer who can seek that direction. But so far as Consumer Protection Act is concerned, that door is not available for the builder developer. Doors are open for the consumers only. The next stakeholder is an agent or the broker. Agent or brokers were never brought under the purview of any legislation till recently the RERA Act was enacted. As a result of that, what was the earlier remedy? Earlier remedy, file a case against the RERA, against the agent or the broker for misrepresentation, for fraud, for several such allegations which you can make. So therefore, that was an option which was available: file a suit, file a criminal case, or drag him to the consumer forum. But apart from that, there is additional remedy, that's a RERA. The allottee or the flat purchaser or the purchaser is another stakeholder in the real estate. He will be a person who should be at a center. He is supposed to be protected under the Consumer Protection Act, but RERA Act aims at the regulation and development of the real estate. As a result of that, under the RERA Act, they have tried to balance between both. One, real estate as a whole, and on the other hand, the consumers. They are treating consumer as part and parcel of the real estate. But so far as Consumer Protection Act is concerned, it is a legislation which is consumer centric. So therefore, consumers are at the center point, and the object of the Consumer Protection Act is very specific: to provide better protection of the interest of the consumer. So therefore, this is one of the important object. I must also make a reference about the object, comparison of object of both these legislations. If we go back to the Consumer Protection Act, you will find in the Consumer Protection Act, the object clause says that this is an act which is enacted with an object of the settlement of consumer disputes. I'm sure all my young friends who are on that side, they are aware about the terminology settlement of the consumer disputes. But whereas if we go to a RERA Act, the object is not about the settlement of the disputes. The object is about the real estate, regulation and promotion of the real estate. So therefore, the object is very clear that so far as the common consumer is concerned, Consumer Protection Act is standing at much better footing. There is one more stakeholder in this real estate, namely a land aggregator. Now, this gentleman or a firm of a land aggregator, they are brought under the purview of the legislation for the first time. They are not the persons who are the purchasers, they are not the persons who are the developers, they are not the agent or broker, but they are the persons who are collecting the lands on behalf of some developer. The architect is another stakeholder against whom you will find under Consumer Protection Act you can file a complaint, or under the general law you can file a complaint. Financial institution is another stakeholder. Now this is one more stakeholder which is also required to be considered. So therefore in near future I am expecting there will be increase in number of cases against the financial institutions, because last 9 or 10 months we have been witnessing a impact on our economy. As a result of that, those financial institutions who have funded flat purchasers, they are in difficulty, and of course it is going to give rise to a further litigation in the near future. Now Dr. Prabhu made a reference in his first session about the redevelopment, and the introduction was given in the correct manner, and there was a reference about the propagation of the self redevelopment by Prabhu sir. Now the question is whether this self redevelopment can be brought under the purview of RERA or consumer or no. It's one of the question, and this can be a one more topic which can be assigned to the students to apply their mind, whether self redevelopment attracts the provisions of RERA, Consumer Protection Act, or otherwise. Now under the Consumer Protection Act, if you purchase a flat for a resale or purchase a housing unit for a resale, then that is excluded, that is not covered. But if we are dealing with the word housing, if we are dealing with the terminology of services, then the time has come, we will have to consider whether the second transaction of that particular flat or a shop, whether that should be brought under the purview of the Consumer Protection Act. One more interesting topic. Some student can prepare a very good research paper on this. A resale of a flat, whether that can be brought under the purview of RERA, because the seller will be an individual person, whether that can be brought under the Consumer Protection Act, because it says that excluding the resale, whether that is required to be brought under the Consumer Protection Act, or whether there is any other remedy which is available. One more question. We are aware about the word TDR, FSI, Transferable Development Right. The FSI violation, Floor Space Index violation, in Mumbai and even in Pune, there are litigations which are with reference to this TDR and FSI. The time is going to come when these litigations are going to come, but before the consumer commissions. Honorable ex-member Joshi Sahib made a reference about the infrastructure issues. And now that's a challenge, because those TDR and FSI issues are going to come before the consumer forum, which are now known as the consumer commissions at a district level, state level, or national commission. Then we as a student of law, we will have to prepare ourselves. Let us make a reference about the one more challenge. We are aware that around 10 days back or 15 days back, State of Maharashtra introduced a special drive about deemed conveyance. Now that deemed conveyance provision was there in the MOFA Act. The conveyance was there. Amendment was made. 1986 amendment was made. However, it was remaining on paper. The State of Maharashtra initiated a special drive to pass the title to the housing societies. However, there was no substantial passing of a title by a deemed conveyance. So therefore, once again, new drive is introduced. Prior to that, what was the situation? For getting a conveyance, cases were filed before the consumer protection, before the consumer commissions, consumer district forums also. Now, whether for getting a conveyance, one can go to RERA. whether there is a need for a better mechanism. These are the challenges before us. I must make a reference about the foreign direct investment which is going to come in the near future so far as the real estate is concerned. I don't know whether you are aware, even today, the foreign direct investment in the real estate sector is permitted. There are conditions. The project should be more than 10 hectare size, namely a township will be there. There should be 50,000 square meter construction built up area minimum. This was introduced. Now, the foreign direct investment which is coming in the real estate sector, that is giving a substantial return to them. So therefore, the time is going to come when the foreign direct investment which has come in the field of the real estate will be coming before the Consumer State Commission or Consumer District Commission or before the RERA or RERA Appellate Authority. Are we really prepared to deal with that? Let us consider one more example. Few years back, Dubai and United Arab Emirates, they were propagating investment in the real estate in those countries. What they were offering? Purchase a flat, invest your money in Dubai or UAE, we will give you unlimited entry visa. Around 5 years back, Greece wanted to come out of recession. So therefore, Greece also brought the similar kind of introduction, similar kind of a scheme. You invest in Greece, in the real estate, we will give you a citizenship. The similar modified scheme is there with reference to United States of America citizenship. There is a higher amount of investment which is required. You will get a citizenship, you will get houses also. So these are the schemes which have been introduced so far as the real estate. I'm sure sooner or later in the real estate in India, similar schemes will be there. Coming to the Indian scenario, it is expected that in 2025, 13% of the GDP, 13% of the GDP will be from this real estate sector. 13%. Let us understand the challenge. If 13% of the GDP will be from real estate, are we prepared to deal with all legal solutions, legal issues arising out of that? It is expected that by 2030, India will have $1 trillion economy. It is expected. And out of that, around 13-15% will be the real estate segment. Let us understand the opportunities which are before us. And therefore, let me point out one more important fact, that now, having realized this, the central government and the union and the Honorable Supreme Court of India, they have started regulating activities of those defaulting companies. Let me give an example. Amrapali, the Supreme Court was required to supervise a project introduced by Amrapali. Supreme Court is supervising the project introduced by Unitech. Supreme Court is supervising different sale of different project by Sahara Group. Why this is happening? Because the Supreme Court wished to give a loud and clear message that there can't be a operate by night and fly in the morning type of a situation in India. You can't run away. There are separate legislations which are coming up, which are already in the field. Money Laundering Act is there. Several other legislations are already in the field. So therefore, this real estate segment is creating a new challenge before all of us. Since two honorable members were there, Dr. Kakre, the sitting non-judicial member, and the honorable ex-judicial member, P.B. Joshi sir from the State Commission, let me make a point. delay in handing over of the possession is treated as a deficiency in the services, and 10% interest was awarded, a usual moderate figure of a 10%. But by getting 10%, whether the person who has been deprived, whether he is going to get the flat in the at the same cost? Of course no, because the return in terms of money, so far as the real estate is concerned, it is much more than 10%. Now it's a time which has come to consider whether 10% or something better than that can be done. We are aware that around 3 months back, the state of Maharashtra introduced a scheme of reduction in the stamp duty if you enter into an agreement till 31st of December 2020. Why? Because they also realized importance of the real estate sector, and to boost this sector, the discount was given, and you will be surprised, in October, November and December, in 3 months, there was a substantial increase in the registration of the agreements. Having said about these few things which are with reference to the new dimensions, new angles about the real estate segment, I must make an appeal to all young friends who are on that side. This is a field of specialty. I'll not call it as a super specialty or super specialty, because it is a field of specialty as on today. And as a student, you will have to learn, you will have to understand in a better manner and prepare yourself with reference to the challenges which are in the field of real estate. Almost more than 50% of the state of Maharashtra and almost more than 60% of the state of Goa is urbanized. On account of uncontrolled urbanization, there are several challenges before us, including the housing challenge. All of us, let us sharpen our skill about the challenges in the real estate and develop our skills about the housing laws. I wish every success to all my student friends who are on that side, and I'm thankful and grateful to the organizers who gave this opportunity to interact with all of you. Thank you.
Yeah. Thank you, sir. Thank you for sharing your expertise and valuable insights on the topic. It is indeed a privilege to have you amongst us in spite of your busy schedule. We have gained a lot of knowledge, and that would surely benefit us in the future. It is a pleasure to be associated with you. Thank you once again. Sir, I sincerely apologize for missing out on important aspect while introducing you. I would like to place it on record that you were twice elected member of Bar Council of Maharashtra and Goa, which is a statutory body. Sir was also ex-vice president of Advocates Association of Western India. Sir was also president of Consumer Court Association.
Sorry, I am a president of Consumer Court Advocate Association. I am, not was.
Sorry, sir. Sir, yes. Again, apologies, sir. Sir is president of Consumer Court Association, Maharashtra, and sir was also a member of committee constituted by State of Maharashtra for framing standard operating procedure under Transfer of Human Organs Act 1994. Sir Advocate Uday Varunjikar was also a member of committee appointed to give suggestions to State of Maharashtra to amend Cooperative Societies Act 1966. He was also a member of committee appointed by Union of India amended preconceptional and prenatal diagnostic technique rules in the year 2013. Sir was also sole panel advocate for MHADA since 1998 and for NCTE and also panel advocate for several banks. He has also been a recipient of Ethical Legal Practitioner Award.
Can I make an appeal? Now, let us go to the next segment. Thank you very much for acknowledging.
Yes.
No difficulty. Thank you.
Thank you, sir. Have a nice day. I now hand over to Sir Pawan Kalwala for a Q&A session. Over to you, Sir Pawan.
Thank you so very much. And once again, I'd like to thank Dr. Vanjekar sir for actually he's the one who has actually engulfed all the laws, and he did a speech, did a presentation on evolving laws of real estate in true sense. So now let us get into the Q&A session. I hope Mr. Chandrasekhar Prabhu sir is there. Sir, are you there?
Yes, I'm there.
Yes, sir. Yes, sir. Yes, sir. For you, there was a question raised by one of the students. He said that 50% of premium amount is been the benefit is given to the builders. How far it will boost the real estate sector? One. Second is whether it is benefiting the consumers. Second.
Uh, I run a YouTube channel,
Yes, sir.
and it is called Chandrasekhar Prabhu Official. There is a YouTube channel on which today morning at 11 o'clock, I gave a detailed answer to this question alone. So, if some of you want to hear in detail, they can go to my YouTube channel, which is Chandrasekhar Prabhu Official. This is for all the students, but let me reply to this. See, the Nasik and Pune builders have said that they will not be in a position to transfer the benefits to the consumer. Why? They are saying that the premiums are paid on the land value in Ready Reckoner, and the stamp duty has to be paid on the sellable value of the Ready Reckoner. So the land value of the Ready Reckoner is much lower, 1/3 or 1/4 of the sellable value. The sellable value, 2% or 3% of the sellable value becomes 10% or 12% of the land value. So they feel that all the benefits, that 50% benefit in premium that they are getting, will be wiped out if they give the stamp duty. So they have written to government saying that we cannot give. The Mumbai developers say that we are giving, but Mumbai developers, as usual, are the biggest sweet talkers, but they don't do anything. Amongst themselves, they have decided that we will congratulate the government, but they will increase the prices if the stamp duty has to be paid. Whatever stamp duty they will pay, they will increase the prices because government doesn't have a inventory on what prices they are selling it. So they will increase the price. If they have to pay at 20 rupees per square feet of stamp duty, they will increase it by 100 rupees per square feet, and they will make this opportunity to make more money. So no consumer will be benefited out of that 50% reduction in the thing. The government is keen that consumers should be benefited. Government has made a condition, made them to give an undertaking that if you give us 50% discount on premium, then we will pay the stamp duty ourselves. But in that, how much rate they are going to sell is not mentioned. So what actually will happen is they will increase the selling price and they will pay the stamp duty. So the consumer will ultimately land up paying more. It will not benefit the consumer, it will be lost to consumer.
Thank you so very much, sir. In short, in the laws we say that it is benefiting the consumers, but on the practical ground, it is not so. We can say that.
No, this entire amendment, uh, is was meant for benefiting the builders. See, imagine who suggested that this 50% discount should be there. Deepak Parekh. Now, who is Deepak Parekh? Deepak Parekh is the chairman of HDFC Bank. Now, 60,000 crores has been lent to the builders by HDFC Bank, and they are defaulted, and they would have gone into non-performing assets, NPAs. So, government should have appointed people like Uday Varunjikar or any retired judge to give us suggestion as to what should be done. But government appoints Deepak Parekh, and Deepak Parekh's bank requires money from the developers. They are defaulting. So he is suggesting you give them 50% discount. All these things are something which are beyond the purview of an academician like me. They go much beyond, and there are many, many more things. So the leader of the opposition versus the government. The leader of the opposition says that you have reduced the ready reckoner prices for Sahara and you have given 50% discount on that. Rightly said. But what is the fight about? The leader of the opposition says you are giving more benefits to the developer. The government says we are giving less benefit to the developer. But neither the leader of the opposition nor the government is saying that if we give benefit to the builder, let us transfer 50% of it to the consumer. That neither the leader of the opposition nor the government is saying. So all politicians together want to help the builder and not the consumer.
Thank you so very much, sir. Edwin, if you are there, sir, Dr. Varun Chilkar, sir, you have a question from Mr. Edwin. I would rather request Mr. Edwin to unmute yourself and you can ask a question to Dr. Varun Chilkar directly. Over to you, Mr. Edwin. Mr. Edwin is not there, so I'll just read out the question. Not a question, sir. It is just a statement. I just need your comment on it. He's saying that when the Constitution itself protects every citizen, why we not do so many different crooked loopholes in the laws? That's what he's asking. And why don't they bring a uniform law for the citizens, and wherein we have a choice that we will not be manipulated as the citizen of India? So over to you, Dr. Varunji, sir. You're smiling.
Question goes to show
Please,
that
throw some light on this.
the question is somewhat non-realistic situation. As on today, we are expecting that we will follow our constitution. We are expecting that everybody will follow, but that is not happening. And since the framers of the constitutions thought it fit to split this land topic between different heads, as I pointed out about the 7th schedule entry. So therefore, there are legislations which are enacted by the state government, like Maharashtra government, Goa government. Apart from that, there are some legislations which are dealing with the land at a central level. So therefore, unless that constitutional framework is changed, there can't be a uniformity in the legislation concerning about the housing or the real estate. Thank you.
A very utopian question and a very realistic answer. Thank you, sir. The next question, sir, the last question is for Professor Chandrasekhar Prabhu. Sir, the question is by a student: is the carpet area clearly defined under Act?
Mr. Pawan, kindly unmute yourself.
Sir, I just now unmuted and I raised the question. Okay, the question is for Professor Chandrasekhar Prabhu. The question is the carpet area clearly defined under the Act?
Carpet area is very clearly defined under the Act, but it is a wrong definition, according to me. I strongly believe that it is a wrong definition because I've been teaching carpet area to the students, graduate students, postgraduate students, as well as some PhD people. What is carpet? Carpet is where a carpet can go on the floor. So if you get inside a room, in a room where you can spread the carpet is carpet area. Means from one wall to the other wall is the length and one wall to the other wall is the width. Length multiplied by width is the carpet area. The what is built up area? The carpet area plus the walls is the built up area. So these are very clear definitions which we teach our first year level student from first semester to 10th semester. All the architecture students get taught about carpet area. Now, the only change in definition, you see, all those whom we have failed in the last 30 years in the exams when I correct the paper for writing wrong definition of carpet area, I will have to go back and apologize to them if they say that the wall should be included in carpet area. Any student writing that wall should be included in carpet area, we have failed them, given them 0 marks. Now, RERA is saying that carpet area is the place where carpet can be given and internal walls within the flat. Now, internal walls within the flat, carpet can't go there. How can you call it carpet area? Don't name it carpet area, give it a different name. But you can't call that carpet area and say that walls are also included. Between two toilet, there is a toilet and there is a bathroom. Now the toilet is 5 feet by 4 feet. The bathroom is 5 feet by 6 feet. So 5 into 6, that is 30. 5 into 4, this is 20. The two together carpet area is 50. But in between the toilet and the bathroom, there is a wall. So under the new carpet area, that becomes 65 because that wall is there. So this is deliberate and this is cheating, total cheating. Carpet can't go on that floor. So how RERA earlier, I must tell you something which I know from personal information. In the first draft of RERA, which has come to me, I can say with all responsibility, the carpet area definition was not changed. It was the same. It was shown to me. I have approved of it. It went to government. It was approved. And then the builders went and met some people. I said, ये तो हम carpet area देंगे तो हमारे पेट पे लात हो जाएगा. तो हमको built up area डालने दो. So they said, no, Chandrasekhar Prabhu has recommended. I was advisor to government at that time. So I have recommended that only carpet area should be, they should charge. फिर carpet area के definition में wall डालो. So they said nothing doing. But then they said कम से कम अंदर का wall तो डालो. तो 15% नहीं, कुछ 5-6% तो हमको benefit दो. And that was a compromise between the politician and the builder. And I don't want to say what were the terms of that compromise, but I know for certain what were the terms of that compromise, in which they changed the definition of carpet area from what is really the carpet area to a new animal called RERA carpet. There is nothing like RERA carpet. All over the world, there is nothing like RERA carpet. Only in Maharashtra, there is RERA carpet, which is carpet area plus 6% or 7% as the case may be. How much the builder wants to cheat the buyer, that he will put thicker walls within the house above the plinth and include that in RERA carpet and charge for that, which is completely wrong. Also, they were permitted to include some areas outside the flat also under the RERA carpet. So these definitions were, these compromises were done later. First, when the draft came to experts, all experts said carpet means wall to wall. where a carpet can be spread. But RERA carpet is a new animal which has been discovered suddenly in the brain of some people. It doesn't exist. It is discovered. It is virtual definition, which is a wrong definition, which is halfway down. See, carpet area and built-up area is about 15% difference. So going halfway down, neither carpet nor built-up, there is RERA carpet is halfway down. So this is what politicians do to destroy the lives of people.
Professor Pawan, can I add one more angle to this?
Yes, sir. Sure, sir.
In last couple of years, the new trend of a litigation which we are witnessing is about the dispute about the actual area. What Prabhu Sahib said is absolutely correct, because a large number of agreements were mentioning, which were executed prior to RERA Act. They were specifying what kind of area, how much area. And now when they are actually receiving the area, which is lesser than what was agreed, and now the builder developer is taking a shelter of the RERA definition of a carpet, which is around 7 to 10% lesser than what was earlier. Similar is the situation about the redevelopment projects. In respect of redevelopment projects, the resolutions have been passed saying that 450 square feet we will give you. But when the actual plans are coming, the builder is showing that no, you will get 405, 410, 415. Where the remaining area has gone, they are saying that because of the new definition, there is a lesser area and the litigation is coming up. And unless and until some judgment is pronounced to that effect or a amendment is made, the common consumer will have to run from post to pillar and pillar to post. Thank you.
Sir, we are looking up to you then. So we are looking up to you, Dr. Varunjikar.
Surely, in an appropriate case, we will definitely agitate that issue also. But since Dr. Kakre is here, who is a sitting honorable member, I'm sure he must have noted this fact.
So carpet means where carpet can be
Dr.
spread.
Kakre, yeah.
Carpet means where carpet can be spread. That there is no other meaning for carpet. Carpet cannot be spread under the wall. So you cannot have wall included in carpet. You call that something else. If you name it differently, it is different. But carpet area definition you can't change. Carpet area is a technical terminology which is being used all over the world, in UK, in USA. Carpet means carpet, from wall to wall, one wall to the other wall, length versus multiplied by breadth. You can't say 2 into 2 is 5 now, because mathematics has been happening since Aryabhat. Similarly, carpet has to be carpet. It can't change. Wall within the house or outside the house, under the wall, can't be carpet. Carpet has to be very clearly what can be measured from wall to wall, where a carpet can be laid. In the bathroom, it could be a rubber carpet. In the passage, it could be a rubber carpet. In the hall, bedroom and kitchen, it could be this thing. So wherever a carpet can be laid in the between one wall and the other, that measurement at the floor level has to be measured, and that becomes the carpet area. That is the definition. It's a technical definition. It's like saying this is the nose and this is the mouth. Like that is carpet area. You can't say I am changing the definition of mouth, and tomorrow you will say this is the mouth. No one is going to agree to you. Similarly, this is a wrong definition which needs to be changed.
So we discussed carpet, we discussed build up. There is one question which is said, which goes like this. Then what is super build up area?
There is, I can say with all the responsibility at my command, there is no definition of super built up. In the theory, I mean, I have been teaching theory of architecture, I have been teaching measurements, I have been teaching building economics. These are my subjects, and I have been teaching for over 35 years. setting Bombay University papers, correcting them. There is no definition of super built up. Super built up is artificial. It's a conjured image which is virtual. There is nothing like super built up. There is no measurement for super built up. Super built up is like a placebo pill. If you are taking blood pressure pill every day and your blood pressure gets controlled, one day if doctor gives you similar looking pill which is not a blood pressure pill, if you take it you still feel that your blood pressure is controlled. Super built up is like that. When you pay more amount, you have paid so much amount, so you get into tension. But if your square feet area is shown as more, then the tension becomes less ki saste mein mila. In that, neither the flat becomes more nor anything happens. It is just a mental satisfaction between the buyer who buys a 500 square feet flat, but builder tells him, आपका सुपर बिल्टअप 900 है, तो ही फील्स अरे क्या मजा आया, इतने में ही 900 मिल गया. उसमें he doesn't get 900, he gets 500 only, but he goes and feels happy. There are two things which I have noticed in my entire career where every individual tells lies. If you ask 100 people two questions, 99 will tell the wrong answer. First is, what is the percentage of your child in the latest exam? If it is 85, he will say 86 or 87. 1 or 2% he is bound to increase. And what is your square feet area? That also he is bound to increase. It is a human tendency to not to admit what is the actual square feet of your flat and give an increased this thing. So builders understood that psychology, and that is why they are catering to the so-called super built-up. Trading in super built-up or making agreement in super built-up, the builder can be sued, and we can put criminal charges against him. But still, though in agreement he cannot write, orally they say super built-up तुम्हारा 1,500 है. Actual measurement is not even 500, but the man feels happy because he goes back hearing that the flat is 1,000 and he gets good night's sleep. So super built up is a way of cheating people, and that should not be encouraged. But unfortunately, दुनिया झुकती है, झुकाने वाला चाहिए. So builder will give you any super built up. I will give you an example of a New Bombay builder where the flat was 373 and he has given writing in certification that the flat is 970 square feet. I went and checked, and court, Honorable High Court, at that time Justice Dharmadhikari was there. He asked me, they appointed me to go and check. I checked, I said it is 375. So the judge was a total this thing to find 375 ka 970 kaisa hua. I said I also don't know. The builder also doesn't know. Somebody who put that number. That became absolute. The same size flat, another person has been told super built up of 1,100. So whatever they feel like, they will tell the people to sell. This is in Navi Mumbai, in Koparkhane. I have been visited that flat, measured, and I have given a written report to the court, and court has accepted that as a technical finding. So super built up is total cheating, and any developer who who even says about super built up should be blacklisted. But then developers run the system. Earlier developers used to pay money to politicians during election. Then politicians became developers. Now all developers have joined political parties, and different political party heads or presidents are developers themselves. So developers have taken over the political system. So what can we really do? But the citizens' awareness has to be built up. That super built up area, even the talk of super built up area is bogus, and that should not be encouraged. Uday Varunjikar sir and others have been
Thank
all
you.
their lifetime fighting. There are rare developers who sell in carpet area also. Very rare. Maybe out of 1,000, maybe one or two, maybe like that. But the other developers, treat them like outcasts.
Thank you. Thank you, Professor Chandrasekhar Prabhu sir. I would rather like to thank all the panel members, the experts, starting with, as I've already thanked Professor Chandrasekhar Prabhu, Dr. Santosh Kakade, Honorable Retired Judge Shri Pradeep Joshi, and our own Dr. Uday Varanjikar sir. Now it's time that we have come at the flag end of our webinar. I request Dr. Sunita Mane ma'am to kindly propose the vote of thanks.
Thank you, Pawan. Good afternoon, everyone. I deem it a great honor to propose a vote of thanks to all who have helped us in making this webinar such a resounding success. First of all, I would like to propose hearty vote of thanks to Dr. Gajanan Egbote sir, Chairman, Progressive Education Society, for giving us this opportunity to arrange national webinar on evolving laws of real estate. I would like to express our profound gratitude to our principal, Dr. Sunita Adha ma'am, and our coordinator, Advocate Dr. Chintamani Ghate sir, for their constant guidance and support. I would like to thank the principal of our collaborating college, Dr. Samadita for standing and making this event a success. I would like to thank our distinguished resource person, Dr. Santosh Kakade sir, member, State Consumer Dispute Redressal Commission, Maharashtra, Mr. Chandrasekhar Prabhu sir, ex-president Mahara, Honorable Pradeep Joshi sir, and Advocate Uday Varanjikar sir, renowned lawyer, High Court, Mumbai, for enlightening us with their knowledge and making this webinar interesting and meaningful. I'm happy to express thanks to Assistant Professor Prajakta Pimpalshande, Law College, Assistant Professor Ruchira Naik, ma'am, GR Kare, Law College, and all the teaching and non-teaching staff who have made this webinar a great success. Finally, the participants who have turned up in such a great number, thank you so much for your cooperation. Once again, I thank all for your cordial coordination. Thank you. Thank you so much.
Thank you, ma'am. Thank you very much.
Now I declare the webinar is over. Thank you so much, everyone. Thank you.